Judge, he objects at everything. Everything he objects to. Everything. I can't speak to Mr. J and his objections, okay? He thinks he knows it all and objects to everything. This is my chance. And this, stop. That right there. The state of Florida has now given the public over 2,000 new pages of Sarah Boone trial transcripts, which include discussions at the bench we didn't get to know about prior. In this video, I am going to go through the discussions at the bench that happened during the actual trial, so I am cutting out everything that happened in jury selection. We start with the court saying, Mr. Owens, have you had the opportunity to converse with Miss Boone about the potential impeachments of her former husband and what answers may be elicited? Mr. Owens says, I have. My understanding is that, potentially, through my cross-examination of her ex-husband, Brian Boone, as it relates to their dissolution of marriage file, that it may come out that she has been in custody for 4.5 years, and it may open the door to that fact. Opening the door. This is taking me right back to the Lori Vallow case that I am also covering. Definitely check that out. If you aren't, it has a lot of shades of Sarah Boone. I'll put it that way. And she's pro se. I have talked to her about that. I was going to talk to her downstairs and get confirmation, unless you want me to spend about 5 minutes with her. The court says, I'd rather do it now because I don't know where Mr. Boone's going to be in the state's case tomorrow, and I'd rather go ahead and do it now. Mr. Owens, I will. And y'all head back to the table, and then, thank you, and it goes back to open court. So let's go to the next at bench. All right. While we approach, can someone from my team start dismantling these things? So I think this is from the state's opening. Yes, sir. Well, I was coming up the elevator this morning, about 8 or so. I think there were 2 or 3 people going to different floors, but I pushed 12. There was already a couple of people in the elevator. I got in there with my suitcase and whatnot. But there was a black officer that came in late as it was closing. Said hey to him, said you got a trial today, said yes, said Sarah Boone, he said yes. I said let's get this done, he nodded. Within just a minute we started going up. One of the females turned like this, and I saw she had a juror badge on. Ooh. Okay, brunette, I think she had a backpack, okay. And so she heard that comment. Is it one of ours? Yes, I believe it is. Okay. There was no dialogue. Those were the statements I made. The officer just, okay. Well, I tell you what, let's do this. Let's bring our jury panel in and see if it's not her. There's no issue. If it is, we can approach and we can address at that point in time. Does that work for everybody? Mr. Owens says, I just felt I needed to say it. And the court says, no, I appreciate your candor. Thank you. And if it's her, we'll approach. And maybe if we have a dialogue with her individually, if that had any impact, we can address it at that point in time. Thank you. I'll open the court. And here's the jury entering. And here is, I don't know if you need to ask, was anybody with Mr. Owens during the elevator? You want me to ask Mr. J? Perhaps a general question. Has everyone been able to follow the instructions? Stay away from the case. Yeah, sure, I can do that. Thank you. So I guess this was actually still at the, so the jury entered. They were still at the, at the, right next to the judge, I guess. It doesn't say they left, I guess. So here it says, all right, in the open court. And juror number 3 rode the elevator. And they approach. Anybody else? Somebody else did too. Oh. Juror number 4, I think it was indicating. And juror in seat 4, left to right, first row. Yes, sir. I think it was one of the lawyers. Let's see here. You want me to ask them in a group setting? I'd say in a group setting, in open court. I think I remember this. And there wasn't any issue. So we'll continue on. All right. And here we are. Right at the beginning of a day. At the bench. Mr. James or Mr. Owens. I don't believe she's in that group, but I'm not positive. Okay. I don't know if you need to ask. Was anybody with... Oh, this is the same thing. So this was at the bench. Okay. And then we continue on. Mr. J, how long do you anticipate your first witness being, sir? I would say... Or Mr. Cacciatore, good morning. Mr. Cacciatore, good morning. Depending on the cross, how deep they want to get, I would say probably 20-ish minutes. Okay, who is it? It's Juan Torres, the brother. Okay. The other thing I would just bring to the court's attention, there's 2 other records custodians as well, one for a 911 call, one for the public's records. I don't anticipate much of any cross on either of those witnesses. Are going to be like 5-minute witnesses. I was just hoping we could put them on before lunch. The court, that's fine. I think we can do that. Thank you. Yes, sir. Mr. J. I would ask that we enforce the local administrative order about addressing people by surnames and not just by their first name. The court, please. Mr. Owens, tell me what I did. You kept calling her Sarah. It's Miss Boone or Sarah Boone. The court, he's correct. There's a local decorum administrative order. Mr. Owens, all right. I know that George refers several times in the video. Sarah. That's a different kitty because that's a piece of evidence that's being admitted. But for the purposes of the parties or the lawyer referring to anyone, I ask that you use full names or surnames. It's appropriate in child cases to refer to the children as their first names, but not when we're dealing with adults. I think this also happened in open court at some point. I meant to say Sarah Boone. The court, I understand, sir. I appreciate it. Thank you. State, you may call your first witness. So they move on. And I know these don't have great context, but I wanted to get through it. There's a lot. It's over 2,000 pages. Can the parties approach momentarily? Who is your next witness? Vincent Battaglia. The court bless you. What? Did he think he sneezed? Mr. Cacciatore, he's a neighbor. I would anticipate his testimony could potentially be as long as Mr. Torres, or it could be longer depending on the cross-examination and issues the defense may choose to explore with him. Court, bless you. I'm on board to proceed because we got a later start. You know, if we've got into the lunch hour a little bit, that's fine. Ballpark it for me. How long you think? 20 to 30? 20 to 30. That's for direct and cross or just for direct? I think it's for direct and cross. Any reason to disagree, sir? I don't know. I'm not asking you to hold yourselves to it, just ballparking it. Are you wanting to take lunch at 12:30? Is that what you're shooting for? Yeah, that's fine. I could do that. I'm okay with that. We'll try to get there. Okay, excellent. All right, thank you. And now they're in open court. To the next one. This witness lives in New Jersey. He has a plane ticket. Mr. Owens, I'll release him. I think this is the neighbor. Okay, thank you. Appreciate it. It's 12. I know my next question, I was going to bring you up. So where are we at? Mr. Cacciatore, I have his roommate, Mr. Motes, who I imagine his testimony would have similar length, maybe even shorter, because he has less interaction with the defendant and the victim than Mr. Battaglia. Okay, I'm inclined to proceed with Mr. Motes and take a break at that point. Is that acceptable? Okay, yes, and they're back in open court. Here is another one here. Can the parties approach? Stopping time. It's 12:18. Yes, we get stopping. What do you say, gentlemen? 1:45 or 2? I'd say 2 if you could, Judge. Yeah, we asked for 2. But the other thing is, you know, I've got a couple of experts. Dr. Harper is in Ocasula County. Dr. Brandon is in Miami. I know they probably know what all they're going to do. If they could disclose something so I could get an idea, because both of them have to travel. One of them, Dr. Harper, has. The court is on trial call somewhere, as I recall. Mr. Owens in Bay County, Panama City. So, Mr. Cacciatore, what do you want to know? Mr. Owens, are you all we're not going to finish today? Mr. Cacciatore, no way we get done today. My anticipated, I think Monday late afternoon, we could potentially be looking at resting. If not, probably first thing Tuesday morning, you know? Okay. Mr. Owens, that gives him an idea. Okay, do you plan on introducing any video, watching the 2-hour video today? Mr. Cacciatore says, no, we won't do. Detective Copesville will probably be Monday. Okay. Is the medical examiner testifying? Mr. Cacciatore, I don't know if we would honestly get to her at this point. We have her on standby for this afternoon, but I mean, it's going to depend. I can tell you that Brian Boone was probably the anticipated next witness, and I imagine he might be pretty lengthy for both sides. And then we also have CSI to do. We also have Abraham Moreno to do. All of those I thought potentially may only get there, or maybe 2, maybe 1 or 2 small witnesses after that. Mr. Owens, okay, that helps. Corpse, I appreciate it. Just a reminder, both of you all have done it. You referred to George Torres as George. You referred to another witness by their first name. I'm not going to call you out in front of everybody. Just please be mindful. Mr. Cacciatore, I apologize, Your Honor, the court. If we could just continue for both sides to use the surnames, it's just the appropriate thing to do. I'm going to give the jury the same instruction I've given them, release them, and ask them to come back here at 2. I've got a question to ask your client before we release her for lunch. Anything else we need to cover? No, gentlemen. Gentlemen, not from the state. No, judge. Okay, thank you. Appreciate it. And at this point, they send the members of the jury out. So did I get lost here? I must have. They had a question for Sarah, right? All right, so there's the court statement. Jury exits. Okay, so this was public. This was public. This was another one of those. Are you satisfied with your attorney so far? Just want to make sure I didn't miss anything else from the bench that no one saw. Here we are at the bench again. The court says, yes, sir. Mr. Cacciatore, the lack of cross-examination has kind of thrown off our schedule for things. We have some Bluetooth speakers coming to amplify the sound. The next item of business for the state was going to be the published 911 call. The court says it looks like your speakers just arrived. Okay, great. The court, you spoke it into existence. If you want to deal with that issue, and then if you can still insist on calling the CSI Abraham Moreno, I believe is who's next. It's not CSI, it's just a regular witness. Yeah. Oh, sorry. Okay, is it Abraham Moreno? It's Abraham Moreno. Okay, thank you. Appreciate it. Must have misheard it earlier. Thank you. Just let me know when you've got all that set up. So this is back in open court. And here we have them at 3:18. Probably a good opportunity for our afternoon break. Where do we find ourselves? I'm glad the court brought it up. So we have two witnesses outside. Deputy Martinez, who's a responding officer, I would say to be roughly in similar length to Deputy Rodriguez. And then we have the CSI, who I anticipate will be a little bit longer, maybe 30 to 45 minutes in length. My estimation was it was probably going to take us to 4:30 hour. The next witness would be Dr. Zidowitz, the medical examiner, who's going to be rather lengthy. And Owens, the cross is... Cacciatore seemed to interrupt him. If it would please the court, it was my hope we could maybe adjourn for a few minutes early of 5 today. After Miss Roughgarden, the CSI's testimony, be able to pick up Dr. Zarowski's testimony in its entirety on Monday with the case. Also, for the court's knowledge, I think we're moving at a pretty good clip, and I would appreciate being able to rest Monday afternoon. Would be my thoughts. The court, give me a moment, just checking with a needle on something. Okay, just confirming that I have nothing else set for Monday because I have a senior judge covering my regular docket. Just confirming that. 1 second. Here we have, yes, sir, Mr. Owens. Mr. Beck wasn't here for that, but the state is saying they may be finished by Monday afternoon. Did you talk to Dr. Harper about? And Mr. Beck says, just received an email from Dr. Harper this morning indicating that she is under. We knew she was under subpoena Tuesday and Wednesday. She thinks she's probably going to be on Tuesday for a capital case in Bay County, so she should be available Wednesday. Dr. Brandon he's under subpoena Monday and Tuesday for a hearing and a deposition. I think he's available Wednesday. That's my knowledge. Mr. Owens, I'm thinking that Sarah would testify Tuesday. Maybe that's because she has to testify first before the court says that's been your all's position the entire time. She has to testify before they can go into battered spouse, if I'm remembering right. Mr. Owens, so if Brandon and Harper can be here Wednesday, Sarah would probably take up most of Tuesday. I'm thinking just right now. The court, okay, all right. Regardless, this is a great opportunity for our afternoon break. It's 3:21 at this point in time. We can come back at 3:35 and give them 15 minutes to stretch their legs. We can pick up with the Deputy Martinez and the CSI and just concluding a little bit early if necessary. Thank you, Your Honor. I appreciate it. And then they send the jury off. This was all public. On to the next one. And then we have an approach. If I understand the state, this was going to be the last witness here today. Is that correct? Yes. All right. I have jury certification for our members of the jury to give their employers about their extent of service. I'll be in the same instruction I gave them before at the lunch hour. Anything else we need to discuss before I give those jury instructions to our jury? State. Not from the state. Mr. Owens, a long weekend, I guess a standard instruction would do it. The court, I'm going to be the same one that I read right before lunch. In addition, don't do any homework. Don't read the local news or newspapers. Okay, thank you. And they move on from there. Here we have another approach. This one has Sarah Boone given her birthday. Yes, sir. Judge, I understand there was a delay and the security said that on Monday it's a really long line trying to get in the courthouse, correct? So they have to go through security. Is there any way, I'm just suggesting, is there any way we get some kind of secret pass to get through the side door like we do? So James Owens wants the jury to have a secret pass to get through the side door. Well, it's not a secret anymore, Mr. Owens. I know about it. People who watch this know about it. Like the video if you know about the secret pass. I don't believe so. Mr. J says, at the front of the courthouse, the far right is a juror interest. I think I should remind them they can use that far right interest and not get to the long line. The court, sure, I could do that. Mr. Owens, that's probably what happened. The court, yeah, that'd be my guess. Okay, anything else you need to talk about? No, sir. All right, very good. And they're back in open court. To the bench again. Let's see here. Talk of 3,000 autopsies. We're going to talk about environmental suffocation. Let's talk about the positional asphyxiation component. What was your ruling on those 5 cases? The rules of positional asphyxiation. What was your ruling in terms of your diagnosis? And there was an objection at relevance with approach. So, okay. And the court asks, what's the relevance of those prior findings? Mr. Owens, I think number 1, she's going to say it's an accident. I think the literature says the majority of the types of positional asphyxiations are accidental cases. The court, so how is that relevant? Mr. Owens, well, it just shows it in this type of scenario with this type asphyxia, positional asphyxia, that the majority of the cases are accident. The court, okay, you repeat the same thing again. How is that relevant? Mr. Owens, his argument here reminds me of Lori arguing her points in open court in front of the judge. Also, her arguments a little bit, we get to hear about it when they have some tech fails and they have to talk about approaching the bench and they have to say it publicly after. Again, 1 second. I have a cough. I do apologize. I am getting sick. Good for me, right? You know, I'm doing the cases. I'm getting sick. It's a thing. I do a case. I get sick. I think it's my sleep getting all messed up. And okay, so they sustain the objection. And here we go again. It's after a witness. What's the state's case? Presentation perspective. Mr. Cacciatore, we have 2 witnesses on deck. I would imagine Mrs. Caskell would be the shorter of the 2 witnesses. We also have Miss Uedon, whose testimony I think is going to be a little shorter. I'll leave it to Mr. J. He's handling those witnesses as to affixing the time frame. Well, the reason I'm asking, it's 11. I don't know if we want to take our mid-morning break at this point in time, and then with a late start, we didn't start until 9:45. I'm on board with working a little bit later this morning. Mr. J, we can ask them if they need a break. Otherwise, we're ready to go with 2 more witnesses before the lunch break. Perfect. Okay, very good. And they continue on. Can I just say I'm about halfway through these, just so you know? Just so you know. So they're back up to the bench almost immediately. This is like literally right here. So Mr. Cacciatore wants to approach. Cacciatore, Your Honor, yes, sir. I want to do this at the bench. We have states F and states N, which were stipulations we admitted to beforehand. We'd like to move those in at this time. It's F and what, sir? N, and N as in Nancy. Yes, 1 moment. I have not inquired of Miss Boone as to whether it's either of these stipulations. Mr. Cacciatore, I believe we did on October 2nd at the time they were signed. The court, I recall having conversation about the stipulations. I'm assuming it's a stipulation as to he's deceased. And Mr. Cacciatore says it's a stipulation, the ID, and there's a stipulation to the FDLE report. The court says, I generally recall speaking about it. I don't recall seeing a signed stipulation at that point in time, so I don't know that I fully vetted that issue. Mr. Cacciatore, okay. Court says, so I prefer not to do that in the presence of the jury. And the Cacciatore says, as would we. So I'm going to excuse our panel for just a couple moments while we have that inquiry. Her, okay. Here, okay. Should we have that inquiry of her? Okay. There's a shorthand instruction to read that stipulations. I have it. I'm pulling it right up. And I believe this was all in open court. Judge James Owens here. I'm here with Sarah Boone. The first exhibit in states Exhibit F for identification. It's the entitled stipulation of victim identification. If it's signed by Mr. Cacciatore, Sarah Boone, myself, October 2nd, 2024. And the other stipulation is a stipulation of FDLE report, again, signed by Mr. Cacciatore, Jr., Sarah Boone, and James Owen. It's a list of identification for identification. States Exhibit N is a 2-page FDLE laboratory report generated June 3rd of 2020. All right, so these got verified. And I believe this was all public. I don't believe this was actually at the bench at this point. And that Sarah didn't have a problem. So we'll move on. All right. A monitor is not working at the bench. Yes, sir. Judge, I don't know how to pull it up. If someone on our laptop, it's not what's been introduced into evidence, I can take the laptop up there and ask if it helps refresh your memory. As that thing that way, or the state can pull the exhibit back up because it's been introduced to evidence. Mr. J, that's what I was in the process of doing. It just doesn't happen. It takes time. The court, okay, well, okay. So Mr. Henderson was just didn't want to wait, I guess. And Mr. Henderson, I just wanted, okay, let's pull it up. Then you can utilize what's put into evidence. Thank you. And we're back. So Mr. Henderson just didn't want to wait. Oh, look, we're back approaching immediately. Prior to the trial, I sent them what was going to be part of the state's case in chief, this carve-out. This carve-out only includes December 25th, 2019. That's the conversations between January 12th and January 13th of 2020, and then the entries made by the phone device on 2/23/20, the date of the murder. They're asking me to publish portions of things that are on a rebuttal disc that has not been entered into evidence at this time and will not be entered into evidence at this time, and unless and until they put it on self-defense claim. Oh. Ooh. Ah, got him. So the defense was trying to have the state introduce into things in the court that weren't in evidence yet. Mr. Henderson was, at least. Mr. Henderson's 25th of 2019 was not introduced. Mr. J, well, what was on the exhibit? That's evidence of 12/25/2019, some entries from there. We published those to the jury, and we went through some of the texts and conversations between January 12th and January 13th of 2020. Then we have the entries from the point in time where it appears the owner of the device began using the device at about 9:42 in the morning, February 23rd, 2020. Through the events, that's what we're here discussing, the last page, the movies. What he's asking me at the sidebar was something that happened an earlier date in 2019, or was it Christmas? Mr. Henderson, no, I said 12/25/2019. Mr. J, all right, so then yes, I can get to that page. The court, okay, thank you. So maybe it was actually available. Give me a second. So maybe the state did have it, and there were, I don't know. That was weird. I know I'm going fast, but it's late, and there's a lot. We're less than halfway. And by the way, when I say less than halfway, I mean in the number that's available for me to search through the document, and I started at 50, and there's 143 total. So we're an eighth of the way through. In reality, for this video's purposes, from the document itself, I'm at number 69. And again, this document, by the way, if you want to read it all, it's there on the website. It's publicly viewable. Completely public. At the bench, yes, sir. Judge, at the end of the session in the morning, we already had some outbursts from the media. I don't know if you want to address that, but this afternoon is the lady in the back row on your left in the very far corner. She's already making outbursts. She's going to cause a mistrial if she's to remain in here. I remember this. She's going back and forth with the deputies. Mr. Owens, I thought she knew the deputy. The court, who might it be? Mr. Owens, the black female in the far back. Mr. J, the female deputy can come up and tell what's going on, I think. The court, my CO, Officer Jones? Okay, are we having an issue with somebody in the gallery? Court deputy. Well, what happened was, when she first came in, I initially assumed she had court herself, which I just told her to go to 19 Alpha. And then, when I came back in, she was like, Officer Jones, you're fired. And Deputy Bruce talked to her, so I assumed she wanted to watch Sarah Boone. That was inmates together, but the court, all right, so what's going on? What I'm going to do, thank you. Mr. J, any further inquiry to Officer Jones? Mr. J, don't you all have anybody else? Mr. Owens is the older man with the court. I recall him being on the phone. Mr. Owens, he's older and he's hard of hearing. I've talked to him outside, so I think it was inadvertent and needs to be. The court, oh, excuse me. Any other inquiry of Officer Jones? No, sir. Counselor, no. Okay, court, okay, thank you. I will advise them to please silence all their cell phones. We're not going to have any outbursts. If you cannot control yourself, I'm going to have you remove yourself now. And if I hear an outburst, you'll be removed. Okay, Mr. J, thank you. The court, thank you very much. Anything else? Yes, sir. Mr. Owens, we have a lay witness. Her name is Pearl Walker. She's an elderly woman. She lives here in the Orlando area. She's cared for by her granddaughter, Marlene Walker. She said this. I understand my mother would be a good witness for Sarah. So that elderly woman the daughter said the mother would be a witness for Sarah. I just have to care for my mom. We have significant loss in our family. Over the last year, my father, who was married to for 60 years, passed away. In May of 2023, my oldest sister and her daughter passed away within days of each other. We have a funeral for them in February 2024. She wakes up most mornings crying due to the loss of her loved one. She's 81. Her heart can only take so much, so I just took her on Saturday to get some shots in her knees to help with the pain of walking. Mentally and physically, it would be a lot to have our mother come to the courtroom. Is it possible she can participate via Zoom? Mr. J, you're looking at me, so I'm going to give a response. Judge, I believe testimony by video is something that should be addressed with a motion so the state can respond and the court can issue a ruling. Quite frankly, 2 out of the, as far as I know from communication with the defense team, have narrowed it down to 3 civilians out of the plethora that we had that are going to call, and this is one of those 3. One of them, I kind of understand what the testimony is going to be based on the phone extraction. That's Deborah Johnson. The other 2 have actually no idea what they're going to say. And I understand that they have an investigator who's been in trial with us every day, rather than perhaps getting affidavits to give us any help. So we're going to require, unless the court orders otherwise, in-person depositions. The court, are one of the persons we're going to identify in your objections? Yes. Court, who was it? Because I only have initials, unfortunately. Pearl Walker. PW. Okay, got it. Based on the court's ruling earlier in this case, if you were going to call any of these people, it need to be subject for deposition first. Mr. Owens. I think we've got some scheduled for as soon as we can get out there. 5:30, we've got witnesses coming to be deposed. But I think Billy Lane has actually interviewed her, and he's got a summary of her testimony. I'll get it to the state so they know. But I do have Marlene Walker and Pearl Walker some phone numbers so they can call. I just talked to them during the break. That's the reason. Giving this information. Mr. J says, I'm not going to talk to witnesses on the phone after unrecorded statements they can't testify to. I need to take their depositions. The court says, that was the court's ruling. Mr. Owens, I understand. Mr. J. But if I had insight, then I could perhaps discuss the reasonableness of video testimony, but I don't have any insight into what these people are going to say. Mr. Owens, can I have them here at 5:30? Mr. J, well, I've got to decide how late we're going to stay in court. The court, okay. Yeah, okay, so bring up the other issues. What are the other issues? Mr. Owens, yes, the assessment of Dr. Brandon, lives down in West Palm. Right. Mr. Owens. Good afternoon. This is 1:34 p.m. Reaching out to see what you anticipate meeting Dr. Brandon. I have kept the schedule open for Wednesday, October 23rd, but I need to know if he'll be needed that day as soon as possible, please. So that's something we need from the state to know whether or not he can testify on Wednesday. And then the other thing is I've got something from Dr. Harper. She's in Bay County homicide or sentencing on her death row case. The prosecution is still on Tuesday. They asked me to be in Bay County tomorrow, which will be Wednesday, and will send me an update 5 tonight as to what time I need to go tomorrow. If it's late, last witness, I would expect cross to be Wednesday a.m. I'll text you as soon as I hear anything at 5. So I'll know something from her at 5 today, 5 Central Time. The court, okay, tomorrow is Tuesday. Mr. Owens, what's today? Monday. Sometimes you gotta take a moment to breathe. I know I'm going fast. Gotta take a moment to breathe. I don't know if I'll premiere this one, because I know I'm talking a little fast, and you can slow it down a little bit. I probably won't put this on a premiere, purely because people can watch it at their own pace, maybe in between the Lori Vallow trial, too. Whew, yeah. So if it's Tuesday today, it's Monday yesterday. The court says today is Monday, so she set to testify on Wednesday in Bay County. Mr. Owens, that's what she says here. Okay, she said she asked me to be in Bay County tomorrow. Will send me an update at 5. Tonight is what time? The court, excuse me, I'd very much appreciate it, but I'll keep your comments down. Thank you. I'm assuming the people were loud. Mr. Owens, I have no reason to doubt that you've provided to me, okay, I don't know the order of proof if you intend on putting on a case. I don't want to pre-state anything, but it seems like Sarah Boone is going to have to go first, correct? And that's going to probably be if you all finish the court. I would assume it's going to be the majority of Tuesday. Listen, we need to get the jury in here. How late can we go? Mr. Owens, okay. The court, assuming go to 5:30, 6 o'clock tonight, still leaves your cross-examination of Detective Copesville tomorrow morning, which you said would be 30 to 45 minutes, assuming worst-case scenario. You start promptly at 9 o'clock, and you're at 9:45, approximately 15 minutes for rebuttal for redirect. Just being worst-case scenario, 10. State rest, we have JOA. I colloquy your client on a couple of things we've got to go over, which means we kick off your case at 10:30. I don't know how long the inquiry will be. I don't know if it's just 2 hours or longer than that. Assuming 2 hours, it takes us to 12:30. We take an hour and a half break. We come back at 2 hours for cross-examination. Basically, Tuesday is Mrs. Boone's testimony, leading to Wednesday. Now, if Dr. Harper is testifying in Bay County on Wednesday, I don't know your order of proof on you want to present. When, where, how? Mr. Owens, we'll probably have to try. Brandon is available Wednesday, so we probably want Brandon. Mr. Beck says, just got off the phone with Dr. Brand's office. She's scheduled to come in Wednesday, although I have to let them know because she scheduled a doctor's appointment anyway, but I think he's available Wednesday morning, first thing, early in the morning, but he's 3 hours away, so maybe 10 o'clock is a good estimate for his arrival and testimony. Julie Harper told us originally she would be testifying on Tuesday. We got an email from her over the weekend saying her testimony was going to be Tuesday or Wednesday morning. That's okay. I think that the court says, I think the text update that Mr. Owens provided looks like she's going to be testifying Wednesday. Mr. Beck, okay, in Bay County. I think we may have to be malleable with this. I don't want to press too hard this afternoon. I just want to try to get as much as we can done. I'd like to have a clean break. I don't want to be in the middle of an examination. We have to pick up where we left off. Judge, of course, I'd love to be finished by Thursday or Friday. We have the jury with the case. Okay, that would be our goal. Fabulous. All right, we may have to just revisit scheduling stuff either at the close of business today or tomorrow. Figure out where we are. So with regard to Miss Walker, PW, look, I already ordered that she's going to have to give a deposition before she testifies. Now, if there's an investigative summary or something that Mr. Lane can give us to the state, they can make a decision what to do. They can waive the right for a depot. That's their decision. With regard to a virtual appearance, I need you to file a motion, explain to me that you've told me, and anything else if the state has provided a summary that may assist in the response in that manner. And the last thing to address is just discussing with our members of our gallery as to the silencing of cell phones controlling themselves in that regard. Mr. Owens says, and then can we ask the jury about how late they want to go today? The court, I am. And based on that, we'll try to coordinate depositions. The court, correct. So the only issue, we may have to send them right back out because one juror, whose number I cannot recall, but where she stipulated has a minor childcare issue where she can't go past 6. We'll have to vet that. If she cannot get coverage, or if it's me and me only, I'll bring you back up here. We'll figure out where we want to go to break because I don't want to derail anyone's presentation in any way. Okay. All right. Anything else? State, no, sir. No, sir. Okay, thank you very much. And they moved to open court. That was long. And we learned a little bit there. We learned a little bit. We learned some new things. We learned that according to James Owens, that the daughter of the elder woman is the one that thought she'd make a good witness, according to Mr. Owens. We also learned that Mr. Owens appears to have just learned that Monday comes before Tuesday. Good thing he did this in the middle of a murder trial. All right. So here we have another one. According to the victim advocate, the defendant keeps on turning around and... According to my victim advocate, the defendant keeps turning around and smiling at the woman in the last row that's going to be the potential problem. I'm really concerned that she's going to say something to derail this trial. Mr. Owens, I'll tell my client not to turn around and talk to people in the audience. The court, I just saw her. Mr. Owens, or make comments to people. Unless you want me to do it, Judge, I'll let you do it. The court, I just saw her turn around and make eye contact with somebody in the gallery, and it was not your staff. Mr. Owens, I'll tell her, or if you want to tell her. The court, I would prefer you tell her, and I inquire of her specifically if she knows anybody and how she knows those persons. I need you to come back and report to me what it is. Pause. Mr. Henderson's the same woman before. The court, can you? The same woman before? I don't understand. Who made the comments to Mr. J? Yeah. Mr. Owens. Sarah Boone says she doesn't know anybody in the gallery. Because of all of that, we just said she was looking to see who it was. Wasn't there talk of her looking at a woman in the gallery? All right, Mr. J. Mr. J, I know it's a public trial, but that woman is going to cause a mistrial. Mr. Cacciatore, at this point, I think she's forfeited her right to be in here. The court, what exactly have you seen her do specifically? Mr. J, before you came in here, she yelled something out. What did she say to Mr. Cacciatore? I believe it was like a loud conversation going back and forth, and just given the sensitive nature of this, we picked 8 alternatives for a reason. We won't be able to unring any of these bells. She doesn't have any business here other than the fact that she's a member of the public. She's forfeited her right to continue to stay in here. Mr. Owens, it is being streamed live. The court, I know that. Mr. Owens, so people can watch it. Mr. Cacciatore, I think the defense is in agreement that she should leave. Mr. Henderson, I am in 100% agreement because of this. If something happens now, we've been into this thing. The court, I know, okay. Mr. Henderson, all the safeguards, Judge. The court, politely. Any thoughts from either the state or defense as how to ask the woman in the back left to excuse herself? So the judge is like, well, how do we get her to leave? Mr. Owens, Just the fact that when the security officers walked in, she said something to her in a loud voice, "Oh, here comes deputy, whatever her last name is. Here it comes," even though it was off the record. You were on the bench. It's still inappropriate in a courtroom. Some people don't know how to act in a courtroom. It was just inappropriate. Then she called out, "Hey, does anybody got a pair of eyeglasses I can wear?" I turned around and I said, "What number do you need?" And somebody in front of her gave her a pair and she tried them on and gave them back. But just too relaxed. She's too relaxed for the seriousness of the proceedings. Mr. J, I think perhaps even before Mr. Owens got in here, when she first came in, the female deputy, Orange County employee, told her to go up to A19. I know you're from the past. I know who you are from the past. So we talked about this woman. This is the same woman, right? I don't know if she's under another defendant or because I couldn't hear what she said. She was up there. I was behind her. She said that she supposed that she was in here for a court and directed her to 19 Alpha, and then it's when the quabbling began. So what about as a request of counsel? You can even put my name on it. I don't care. Mr. Henderson is like, yeah, have her leave. The court, all right. Mr. J, she had another outburst when she said she's the mayor of Orlando or in charge of Orlando, the entire city or something like that. We didn't get this. I am so glad we got this. The court, I got it. All right. So here's what we're going to do. I'm going to say at the request of both the state and the defense, ma'am in the back left, last row, I need you to excuse yourself. You were able to watch it live. The court link is streaming. You can go to the 12th floor and call my JA, and we'll give you instructions how you can watch from a streaming device. Is that acceptable? Thank you. Yes. And then we're back to open court where that gets said out. And then unidentified speaker responds with, "God bless you guys. I'm still the boss of the city. We've got work to do together, so trying to figure it out." All right. Thank you, ma'am. So they got her arrested. Have a good one. And then she left. Okay. We're back at the bench another time. What is this here? Oh, it's the woman with the child care. And this is very short, I'm pretty sure. I think it's just a juror saying that she can do the child care, so that's fine. Mr. Cacciatore, we're going to a place where I would like to introduce a second interview. That's a 2-hour one. I see it's about 3:30 right now. Do you want to take our afternoon? I'm going to try to skip the ones where it's just taking a break. So that we skip that one. So here we have Mr. Owens. I'm asking for this before, but I'm asking instruction 2.8 be read to the jury. It needs to be tweaked. It's 2.8 recorded interview. The effective law enforcement statements on defendants. One of the pleadings, I believe the state, but instead of, you're about to hear, you've heard a recorded statement that contains opinions and statements by officers, Detective Lowe and Detective Copesel to Sarah Boone. You've heard a recorded interview. Any objections? No, Your Honor. Okay, thank you. Hang on. Wait, gentlemen. You have additional questions you want to... 2 or 3 more. 2 or 3 more questions. All right. You want to finish it up and then pick up back on cross? Yeah. I thought there were going to be 2 or 3 more questions to the judge. And then they end, so that's just a time thing. Here's Mr. J saying we covered it at the bench. That's not a new at the bench time. And at the bench. 1 second. The judge says, my takeaway, Mr. Owens, is you did not have the opportunity to review it, so I was tabling it for the moment. So this is about something that was e-file that he didn't get to see. Mr. Beck, well, it should be done in camera, is what I'm saying, not in public. Mr. Owens, this is not in camera right here. It wasn't. The court, we're at a sidebar. I don't know if it's in camera. Nonetheless, you're in a position to address it now. I'm fine with that. My takeaway is you were not. Mr. Beck, I briefly looked at it. They haven't even looked at it. I was just trying to understand where he was coming from. Is he saying that we're going to request costs for post-conviction travel costs? Mr. J, do you want me to say what I want to say? Mr. Owens, yes. Oh, we're getting spicy. Sounds like we're getting spicy here. Mr. J, okay, here's my concern. The defense team is comprised of 4 attorneys, a trial jury consultant. I don't know what their backup support staff is, but beyond that, the only thing that I notice is getting paid for by JAC is a bill I Lane. And the experts. Beyond that, this is a tremendous expense to come down here, shut down. I believe he described it as shutting down his practice for a month and coming down here and speaking to one of the other members of the team. It seems like other members of the team are getting paid by Mr. Owens, and at the end of the day, I'm just wondering where this money is coming from. Is this just a charitable gift? Which is fine if Mr. Owens wants to provide a charitable service and get his pro bono hours for doing this case with Miss Boone. That's fine. But there's some sort of deal with Miss Boone about story rights, anything like that, then becomes a potential conflict of interest. I don't want to make her I don't want her to make allegations in a 3.850. If she gets convicted, you all know there'll be an appeal. There will be a 3.850 if the appeal fails. And I don't want anything about a conflict of interest saying, well, I would have paid, but my attorney didn't do what he should have done in getting me to plead, for example, because of the contractual arrangement we made for how he's going to get paid for all of this. So the state doesn't need to be part of it. We would just prefer if there was an in-camera hearing, so this all can be put on the record, and if there is an actual conflict, whether Ms. Boone under the case law knowingly, intelligently has any conflict for purposes of 3.850, after that in-person proceeding, it can be sealed and unsealed if there's a 3.85 someday. Mr. Owens, I think we need to address it later. There is no deal. There is no conflict. Okay. So he's outright. So they need to address it later, followed by a denial. Okay. The court, I'm going to give them the opportunity to review it. Mr. Owens, we're going to address it on the record. The court and discuss it themselves. I'm not going to address it right now because, by your own admission, Mr. Owens, 2 or 3 of the members of your team have not reviewed it. And Mr. J, I do have a slight correction. My understanding is Mr. Henderson's daughter was recently barred, so there are 4 attorneys working over here. Mr. J, that's what I said. And the court says, I thought you said 3. I apologize. Mr. Owens, she hasn't filed a notice of appearance. The court understand as attorney of record. The court, I get it. Let's table it. I'll look at it during the lunch hour and we'll readdress if necessary this afternoon. Anything else we need to address, Mr. J? No, sir. Anything else we need to address from the housekeeping perspective for your all side of the ledger? No, sir. I don't think so. Let's go ahead and bring in our jury and I'll short colloquially your client, then we'll bring in our panel. Open court. And this is all open. Back to at the bench. Let's see here. We have an objection. They ask about who was with the witness when they took Mr. Moreno's statement. Mr. Cacciatore objects. She hasn't said that she needs any aid in refreshing her memory. Okay, so Owens, I think it was trying to get her to read something and she didn't need to read it. Objection sustained. Ma'am, was Detective Scott Lowen with you during that interview? Yes, I believe so. Mr. Henderson, may we approach? Yes, so now. This is Sarah Boone's side. Yes, sir, Judge. I believe so. It is not an answer. I think the report clearly shows that it's in, and I think it can refresh her memory. The court, she hasn't established that she can't recall. If you believe it's a contradictor, then impeach. But she has not said she can't recall or doesn't remember. She goes, I believe so. That is not a lack or gap in memory. Okay, so that was nonsense. Here he is again. Master Cacciatore saying, Your Honor, I would again object. She hasn't indicated she needs assistance with her memory. Approach. The court, I'm struggling with the refresh. She's not establishing a lack of memory. Mr. Henderson, okay, I think I remember this. So this is a back-to-back-to-back ones. And here we have a question. Did you tell Miss Boone in arranging the meeting that she came down there she was going to be arrested? Mr. Cacciatore, Your Honor, I'm going to object his relevance. Approach. Response. Mr. Henderson, I think it's very relevant. I think one of the things that go to an interview, and it's actually in the jury instruction, they can look at the voluntariness of the interview, and if the jury doesn't think it was voluntarily given, then informed, they can regard it weight they want to give it or disregard it all. Mr. Cacciatore, the voluntariness of the interview would be determined by the subjective state of Miss Boone during the interview, and that information is on ops or is on the camera there at the sheriff's office headquarters. The determination of whether or not she was going to be arrested beforehand, Miss Boone wasn't aware of, could not factor into the voluntariness of her statement. It would have been conduct of the officers that was displaying towards her at the time. And that makes sense, right? Like, oh, well, she didn't know afterwards she was going to be arrested, so her interrogation was messed up. How is her interrogation messed up if she didn't know she was going to be arrested? If she knew she was going to be arrested, wouldn't that be more likely to change what she's going to say? Okay, any further argument? Mr. Henderson, yes, Judge. At this point in time, Miss Boone was told that she was arrested. A lot of people would reach out to an attorney at that time and say, and some legal advice go about there, and might even have the attorney go down there with them. Okay, any further? No, I'm going to overrule the objection. So the objection got overruled. And she had to answer that she didn't tell Sarah. And here we have, ma'am, was it a strategic decision to not tell Miss Boone that she was under arrest prior to reading those Miranda warnings? Wow, this video is longer than I thought it would be, and we are not close to done. Maybe I won't finish it tonight. At the bench, how is the sufficiency of Miranda a fact of consequence for the jury to consider? Mr. Henderson, it goes with the voluntarians first statement, Judge. The court. But isn't that an issue of law for the court that was previously decided in the motion to suppress? Yeah, we already went through this. Mr. Henderson, the issue of law for the court if the statement comes in, but to the weight they give the circumstances around the statement and everything else that takes place around the statement is totally relevant. Anything further? Mr. Cacciatore, Your Honor. The jury instructions don't contemplate the jurors relitigating the motion to suppress. They are given specific instructions that deals with them weighting the voluntariness of the defendant's statements. But that analysis is predicated upon the objective four corners of evidence of the defendant's statement, the conduct of the officers on video towards her, the facts that the defendant would have been aware of at the time, but in that analysis, the officer's objective intent is really irrelevant. What's relevant is their objective conduct towards the defendant and the facts that she would have been aware of. The court, anything further? Mr. Henderson, yes, Judge. I believe there's a difference with people when they know they are under arrest because when the Miranda warnings are read to them, they have a different idea before they are read it. And I believe law enforcement knows that. I believe this is a strategic decision for her because she's going to be more likely to talk to us about this knowing that she is not under arrest. In the court, I'm going to sustain the objection because I don't think it's subjective analysis from law enforcement. The questions seem to be geared toward the officer's subjective analysis. It's whether or not the jury instruction 3.9b as to whether there was a force or whether anyone promised and whether it was freely or voluntarily made, it seems to be for the perspective of the defendant, not of the perspective of the law enforcement, so I'm going to sustain the objection. The objection was sustained. All right, so what's this one here? More talk of timing, I guess. I understand it's what you want. What is you want to do? I get that you have not participated in the viewing. My pressing concern with our time with the jury, we have wasted substantially amounts of it. Mr. Owens, I don't know if I would say wasted. I mean, we've been working the court from their perspective. Okay. And the court, okay, so they're sitting in that room waiting to be brought in, and now I'm going to bring them in, excuse them again for an early lunch. I understand that's a lot of work for everybody who's doing an excellent job so far, but you need to try to be more effective with the time we have. If there are exhibits that either the state or defense intends on using, let's pre-mark them during this break, all of them. So we may not the rebuttal evidence because the defense hasn't rested yet, but at least for any evidence you intend on listening over the next couple of days, let's go ahead and pre-mark it so there's no concern, no question, no last-minute markings. If it comes up, we will address it. Can we do it during lunch? We're going to recess the next couple of moments. Mr. Owens, can you give us the clerk some time? The court, I love Madam Clerk, stay behind so you guys can do it. I don't know that I need to be there for that. The state should probably be here for it to confirm it. I'll probably bring the jury in. I'll ask them to be back here at 1 o'clock, and at 1 o'clock we need to be ready to go. Understand and judge, if I started, I wouldn't be finished before lunch. I understand that. It would be broken up anyway. The court, I agree. I'm trying to avoid it. Mr. J, Judge, I had the opportunity to take deposition of 2 witnesses last night. I'm just curious as to when this third witness is flying in from Jersey. It's going to be deposed so we can start making arrangement with the court reporter. Who was it? I think it's Deborah Johnson. I think these are people that 4.5 years ago were tenants of the apartment when this occurred, but they have all dispersed. So you took PW and who else last night? I have to see her full name. Last night is G. All right, MG. All right, got her right, and that's okay. What do you expect Ms. Johnson to be arriving from New Jersey? I expect to contact her last night, Your Honor, and she was asleep. Okay, we're trying to work with United Airlines. We'll try to skip through a little bit here. Arrival time at 9:05, either lunch hour or Wednesday evening. I don't know when the defense intends to offer that testimony, but my pretrial ruling remains the same, that before those persons are allowed to testify, the state has their opportunity similar with you. As a rebuttal witness, you'll have the opportunity as well. Do you have an opportunity to address the USB to CD conversion because it's on my list from yesterday? Mr. Sanders, we have another guy approach the bench. Where are we on the USB to CD conversion? I have all the videos in separate. I have all the videos in separate videos, separate discs. Here's what we're going to do. Bring the jury in, give them the same instruction, ask them to be released for lunch, return here at 1. You'll have the opportunity to inspect the bat, inspect the suitcase, mark everything will return promptly at 1 o'clock. Anything else, state? Judge, unfortunately, because I just got aware of their actual redaction request today, what I'm going to have to do is mark something for ID to go over with Miss Boone during the cross-examination, and we're going to have to reach out some sort of agreement as to whatever letter that ends up being. X will be allowed to be substituted for Y after the redactions are made, that they are requested if the state has any. I'm referring to body cam video. I'm referring to the body cam videos and 911 calls. I want her to authenticate. The court, here's what we discussed previously as with regard to 911 calls. The 351 timestamp redaction, in the body-worn camera regarding arrest. It takes time for the state's AV team to make those redactions, so I don't know if that needs to be a stipulation. That's what's wrote up and provided into evidence that won't be back to the jury or something that is just a stipulation that's announced in open court. Any thoughts on that, Mr. J? Mr. J? got to go back and do all this work and kind of sort of what we're going to see. If things are the state wants to redact now, they've gotten their inputs. I generally don't litigate against myself, so that's what I'm asked to do. Go to these files, Ms. Boone. I will obviously have to be outside the presence of the jury because the audio at some of the end are crossed, but it's just going to be done before then. Okay, in response to the procedure, so it'll be authenticated outside the presence of the jury by Ms. Boone. My Ms. Boone during cross-examination for potential admission. Once the redactions are made, be pre-marked as X when we'll receive will be Y, and will be the redaction of X without any additional. This is a lot of nonsense. So now they're just saying they're going to stipulate it instead of it being authenticated, so they're just disregarding all of that. The bat in the suitcase, there's not going to be any demonstratives or anything done with those. Mr. Owens, well, the jury never got any closer than up here. That may be the jury to get a closer view of it, bring her down. I want to show the jury, so I may hold the suitcase and we're standing next to it to show how she left it in terms of, well aware the suitcase has 2 zippers and they met at various points along it. The court, there's not going to be any other manipulation of the evidence other than operating the zipper, similar to how the CSI tech, whose name is escaping me at the moment, Rough Garden, thank you, and opening and closing, okay. She prepared to stand down or in cross-examination to come into the well too, very good. Without I accept your stipulation, not requiring authenticities with regard to those items, we'll bring back the panel, reconvene at 1. And this is the end of that bench part. Whew, that was long. What is this here? Is this Sarah's testimony? Yeah. This is Sarah's testimony. So Sarah says he asked me, yes, a couple of times to marry him, and one time I agreed, yes. Okay, now I want to get directly to the date of this event. The jury can hear your testimony. All right. Tell us, I believe the date is February the 23rd of 2020. Explain to the jury that whole day from the time you got up, the whole thing. Objection calls for a narrative. Approach. Response. Mr. J, I'm just making sure, is there a reason for the narrative? Mr. Owens, I can break it up. The court can go ahead and break it up. It's not any. Mr. Owens, was anything wrong with me saying, can you tell me what happened that day? Let her tell it. He was wanting a narrative to begin with. I'm giving her the opportunity. Mr. J, here's the issue. I was just making sure that we weren't in the stage of the ethical issue of having to give the narrative. But if we're not, then I'm just hopeful that, like a prosecutor would have to do, that he would come up with a few creative ways of saying what happened next so that I can, so it's not a narrative. We can break it up and object. Basically, Mr. J wants a way to object. Mr. Owens, you see me guide her. She tried to go off a couple times, and I tried to get her back. The court, I'm not going to allow a full-blown narrative. If you want to start morning, afternoon, and break into chunks of time, I'll allow that. Appreciate it, and they go back. Here's another objection here. Sarah doesn't remember videotaping. Did that refresh your memory about that event? It did. Why did you say all that? Objection, maybe approach. Mr. J, Judge, it's my position that we have not established an overt act. I understand it's one thing to allow her to testify about while she did these things, but I don't want her to be considered a waiver of any objection about her reputation, past violence, and battered spouse syndrome coming in a different way. The court responds, well, Judge, this event is broken down into 2 minutes. Why did she say what she did and was recorded? I think she's going to say I was angry at him and he was in a confined space. He was not free to get out, and it was my chance to tell him how I felt. And then, of course, 11 minutes later is the 22-minute video. 22-second video. Right. 11 minutes later, the 22-second video. But there's an 11-minute period where she's got to testify about what happened during that time. So, I don't know. I didn't know she was going to say she was incarcerated. And the court says, I know. I don't think anybody anticipated that. Mr. Owens, so something's come out of clients' mouths that we don't expect. The court understand. Mr. Owens, if you want to proffer it outside the presence of the jury, but I think she's going to say, why do you say the things in it, that 2-minute video? And I think she's going to say, because I was angry and I want to tell him how I felt. And that's what I believe the answer is going to be. Not because, well, you choked me, what you've done. The court, is it possible, the question, to avoid any prior instances coming out at this point in time, is it possible to rephrase the question specifically as to the feelings she had been having at the time In the point in time and only those things. Okay, so we can avoid that issue. Okay, all right, and we're back to open court. Next bench. We have George drinking. How did it affect you? Why would he get that way? Tell us his pattern as it relates to drinking. And then, judge, objection, approach. Judge, I don't think pattern is appropriate if there's specific instances of violence that the court. Are we getting into reputation? What are we getting into? Mr. Owens, I think it's consistent with what I have argued before. There were times when, he would drink and then she would just, over time, get to know a person. You're living with them. You're an intimate partner. Over time, you learn what goes into a certain level of intoxication. Then he gets sad or moody and eventually gets angry and belligerent. And there are times when he gets violent with Sarah, who is just a cycle. That's why she said I was trying to keep him occupied all day, because she knew that if he's got alcohol there to drink, he's going to consume it. And it might get to the point where they get into a violent episode. And that was just, they were together 3.5 years. So you can imagine there was a lot of history of that going on. I'll refer to it as the court. Any further argument, Mr. J? I think it should just get into specific dates to get into those, because one person is not a broad enough community for reputation evidence under the rules. Mr. Owen says, and she's not going to remember every date, Mr. J, let's go through what she remembers. Mr. Owens, excuse me? Mr. J, let's go through what she remembers. Mr. Owens, part of the syndrome. The court, uh-huh. Mr. Owens, part of the syndrome of battered spouse is depression, and then not having a good memory about all the events due to each repression or whatever the doctors testify to, but there's going to be evidence that. The court, my concern is utilization of the word pattern. It sounds like we're getting into habit evidence here, which is, I don't think, something you can get into. Now, if you want to rephrase it and say this is what would happen if there was circumstances that seem to continue, it may be a different story, but the word pattern is something I've got a problem with. Mr. Owens, tell me what you all are thinking about, because I don't want to violate the court's ruling. The court, my understanding based on the case law is there can be reputation evidence for prior incidents. We're kind of dancing between the two of those. But this is generally what would happen. He would drink, become emotional, become sad, and then aggressive. The state's concern is that the use of the word pattern, which I think we're going into habit and routine practice, which I don't think is permitted for the circumstances you're trying to offer it for. Okay, so you can rephrase it, and then we can start getting into specific instances. Okay, thank you. The objection is overruled for now. This is one of those cases where we didn't know why it was overruled, and now we do. Interesting. Fascinating. So now Sarah is asking about her dogs, and Mr. Owens asked for a break. Court, just from a timing perspective, where are we in your direct examination? I want to say about 20 more minutes. Mr. Owens, 30 more minutes. How long do you anticipate your cross-examination being, Mr. J? Probably an hour. Can we inquire the jury about 6? The court, I can. Do you want to take our afternoon break? And I inquire if they're on board with staying later this evening as well. Mr. J, if we take the break now, then we're just hopping right into cross. Yes, whenever they want to take the break. Whenever you inquire about 6, I'd rather do it now. Perfect. Excellent. Okay, excellent, sir. Yes, sir. Mr. Henderson, we have 2 officers out there on standby. Can we tell them, Mr. J, that's not going to happen today? The court, based on it's 4 now. You said you have 20, 30 minutes left. He has an hour and a half for the cross that takes to 6. Mr. Henderson, yeah, I just want to let them know. The court, if you want to release them and tell them to be back here tomorrow morning, that's your call, but I would be surprised if we get to them this afternoon. Okay, all right. And they go back to court. On to the next break. After the jury comes back at some point. Just a request from the jurors as related to me by the deputy if the pictures are going to be shown, if they can be tilted so they're not landscape and vertical because they're tilting their heads in a weird way to see them. Mr. Owens, my bad. So Mr. Owens was displaying the pictures poorly. No worries, just for the future, just want to let you all know. Okay, thank you. Mr. Owens, can I show them the demonstrative aids? Okay, I'll leave that to your discretion. Okay, all right, we're back in court. Here we are back at the bench. This is after... Okay, so this is Sarah explaining what happened after she got to the station, and Mr. J wants to approach. So the prosecution wants to approach. Local administrative order surnames. He's right, so please open the court. Oh, I see. Sarah, tell the jury that this was where we got to hear that Mr. Owens has to call her Miss Boone. See? And it goes right to Miss Boone. So more, I love the timing of this. Okay, so now we just had a sidebar. He switches it to Miss Boone, which sounds more formal. Tell the jury why you lied to the police. Just the setting of that is pretty humorous. All right. All right, so this is Sarah saying she believes she's still intoxicated, and Mr. Owens says, okay, so it would be fair to say that you're still feeling the effects of alcohol at 1 p.m., so that's 14 hours by 0.15. We were approximately about 0.21 at 11 p.m. the night before. Do you feel like you were 2.5? Actually, this is going to be the state asking this. So do you feel you were 2.5 times the legal limit at that time? And the answer is, I don't know how you came to that answer. Judge, I'm going to object. Approach, Mr. Owens. Judge, she doesn't know the science. She doesn't know the calculations. He's just making the calculations. She's not aware of what she was. She said she was hungover. She was feeling the effects of alcohol because she was hungover. That was her testimony back then when we took the motion to suppress. That was her testimony. She was feeling the effects of alcohol because she was hungover, not because she was intoxicated. The court, he read the citation from the transcript, and the court's recollection is Mr. Owens, improper. The court's recollection of what she testified to previously, that she was hungover. She was still intoxicated to an effect, which is in line with Mr. J had just read, and there was no objection to a proper impeachment at that time. Now, there is the objection now, I believe, to the question of what her level was, which she just responded she doesn't know. She doesn't know how you did that math. Mr. J, that's fine, I'll move on. So that was the argument about how drunk she was. Let's a little bit here. Was when you hit him on the hand, but all the other injuries were you poking him pretty hard, correct? I mean, it bruised your hand, correct? Correct. Thank you, that's all I have. Ma'am, you can return to counsel's table. Judge, can we approach? This is after, I believe, Sarah's cross. All right, Mr. Henderson has some bad news. Okay, what's the bad news? Mr. Owens, I said you've got some bad news. The bad news. Mr. Henderson, can you get a little closer? Oh, yes. Judge, I let the officers go. I told them, like I informed the court, that I was going to do based on the time schedule that we're in. I know we were over. That's fine. I didn't think it was. It's 5:54. We don't have any witnesses. I understand. We'll pick up tomorrow. That's fine. No big deal. That's okay. I anticipate the cross to be a little longer. I think we may all have, but it's no big deal. Gentlemen, anything we need to discuss? No, sir. And let's briefly get ready to rock and roll at 9 a.m. Yes, sir. Mr. Beck, I was just curious whether or not we're going to address the motion to stay filing this morning in camera this evening, or we're going to do that later. Court, I'm not addressing it yet. We can address it later when we get closer to jury instructions. Mr. Beck, that's why I was curious. Mr. Owens, we've got an issue. By 5 today, you had ordered us to have redacted down to the medical records. We need more time, Judge. Can we have a little more time? The court, here's my concern. Mr. Owens, Mr. Beck is working on it. The court, here's my concern. Is Dr. Harper is supposed to testify on Thursday, and the state needs to understand what it is you all are looking for. Mr. J, that's not the issue. I'm familiar with all the records she relied on, and they can, of course, rely on stuff that's inadmissible. Yeah, of course. Well, my concern is what particular pages do they seek to introduce? Yeah. Mr. J, so it's a completely separate issue. I just need to know what they're seeking to introduce, to see if I object, to see if it's complete, see if it's incomplete, and so on and so forth we did with her records. Mr. Owens, can we get an answer in the morning? When you anticipate moving into evidence? Mr. Owens, I need to talk to. I believe there's case law. We can recall the client. I believe she was going to testify to something that happened, and I believe it was he got mad at her, and he rammed his fist through a glass window or something, and he got cut, so he had to go to the hospital. Okay, hang on. That evidence was going into those medical records. The court, let me do this. This is going to take a couple minutes for us to figure out. Let's get the jury out of here so we're not wasting their time, and we can go from there. So here is an open court. I don't know if this is still at bench, so I'm going to continue. With regard to these medical records, the court previously said today required by 5 p.m. to address those. Unfortunately, they have not been addressed. It's imperative the state knows what is or culling down or redacted, and I understand you may not be seeking those into evidence, maybe tomorrow. The state needs to be advised as to what it is, what you're seeking to utilize, so where are we figuring that out? Can I have 1 minute with the client? Yes, sir. Mr. Owens, Judge, we had a discussion with Miss Boone. She claims that every time he went to the hospital and medical records would show that it was a retaliation, some sort of domestic violence involving her. We expressed to her that we do not wish to pursue it and introduce those records of George Torres and his medical records of the different times he went as it relates to their difficulties. Let me reread that, because that's interesting. Judge, we've had discussions with Miss Boone, and she claims that every time he went to the hospital, and the medical records would show that it was in relation to some kind of domestic violence involving her. We expressed to her that we do not wish to pursue it and introduced his records of George Torres, of his medical records of the different times he went as it relates to their difficulties. Do you understand that? Yes. So basically, I think this was public, but basically they're like, look, we introduced this. They're going to know how many times there was violence involving you. That's how I take it. I think this was public. Yeah, this was definitely public. I remember this talk of strategy thing, so we can move on. But I'm just trying to hit all of the at bench. Yes, sir, Judge. Dr. What was this here? Okay. Dr. Brand was supposed to be our next witness. Mr. Beck informed me that she's not here yet. Have you contact with him? I have contacted him via text this morning. He indicated he's going to be arriving at the courthouse around 9:30. Okay, do you have another witness that we might fill to bridge the gap? I'm trying. Scott Lowen is here. The court, Detective Lowen is here. Yes, the detectives are here. Can we do that? I'll do that. Appreciate it. Okay, they swapped witness order. Let's just start up here with this question. We'll get into it. All right, the statement would be that Sarah Boone said to Mr. Moreno that she was teaching him a lesson and things got out of hand, that she fell asleep, and I'm wanting to know, did you say, okay, I thought I heard you say passed out the first time. I'm not sure you said passed out or fell asleep. Fell asleep, okay. What I'm asking is there any indication that he told you that statement on the date of the interview on 26? Sorry, I'm trying to go to the part where we talked about that. Yes, ma'am, take your time. Okay. Okay, so like I had stated, there were certain things that I thought was accurate from your statement. He stated, I just exactly what it says. Do I need like the next number to it or anything like that? Yes, I have no problem with you reading what he said. Okay, then, Mr. Cacciatore, Your Honor, I would object. Approach the court. She's refreshing her recollection as to the statement. She can't read it. Mr. Henderson, I'm sorry. I agree. Objection is sustained. So that was quick. Let's see here. Defense, call your next witness. Dr. Brandon is here. All right, making sure. And Mr. Henderson wants to approach. Judge, I had two other witnesses scheduled this morning. Scott Lowen, who, because of testimony of the past deputy, we do not need any more. Okay, so you're not going to be calling Detective Lowen. He's been released. Okay. I also have Abraham Moreno. He's being released. He's not going to be called. So they were canceling witnesses up to the last minute. Do you have any of them state for your rebuttal? No, I went out and released Lowen. I think he'd release Moreno. And then Judge is going to leave us this morning with Dr. Brennan, Mr. Beck, Dr. Brennan are talking at this point. So what about Scott Lowen? Scott Lowen was just released. He's released. All right. He's here. He's using the restroom, though. All right, very good. Rajesh, should we take a break before we get started? No, we'll just hang out. We just hang out. Thank you. I don't know how long he's going to be. It's okay. An open court. You continue on. About how many times have you testified? Wow. At last count, it was about 1,500 times. It's over that, way over that now. That was for a few years ago. I testified in a lot of different kinds of hearings and trials over the course of mostly in Florida, but in other states as well. Now you're familiar with the fact that this is a special jury instruction that's been recognized by the Florida Supreme Court. This is going to be about, it's got to be about battered spouse. Objection, approach. The court, legal grounds of the objection, Mr. J. He is not qualified to go into legal opinions, and quite frankly, the law is the purview of the court, and we don't know whether the special instruction is going to get given. The court, what are we doing, Mr. Beck? Mr. Beck, just having him indicate the battered woman is identical to battered spouse as indicated in the jury instruction. That's just the same terminology, same issue. The court, I'm hesitant to address jury instructions, Mr. Beck. Okay. The court, we haven't had a charging conference. We haven't agreed to the language of the 3.6F instruction. That's very long. I read it yesterday. I'm going to sustain it in part. I'll allow you to address the battered woman and battered spouse or similar in the field that he's in. I'm not going to allow any jury instruction at this time. What instruction is that? 13.6F is the self-defense instruction. All right, and now they're back. So they were trying to work in a jury instruction early. Okay. Now, what's this one here? It's about the witness at this time, Your Honor. I proffer the witness expert in the field of forensic psychology. Objection, may we approach? Mr. J, there's a long-standing case law that says it's inappropriate for a court to do that. The court, I agree. So his qualifications speak for themselves, but I'm not going to accept a tender in the open court. Tender in the open court. Okay, and they're back. Objection sustained. Wait, Mr. J, back. Will there be objections as to his ability to proffer opinions? No. Okay, I just wanted to make sure, and now they're back. All right. What's this here? Does the experience that they have suffered result in an occasion they're experiencing, they're anticipating, or assuming, or imagining a threat that others may not? Yes, sir. Objection may be approached. Yes, sir. Under the case law that I cited, and I can't name the case offhand without stopping and reading it, but this is exactly what is not allowed for PTSD. It is not allowed to come in to show why something is subjectively making somebody act differently than the ordinary, objectively reasonable person. What this evidence comes in is, like he explained earlier, is to show how it's objectively reasonable to do things like refuse to leave or flee. What was not allowed as well, I was in Vietnam and now fireworks scare me and make me think that it's gunshots, and that's why, I heard fireworks and went outside and shot my gun everywhere. So it's our position that this is legally not relevant under what PTSD battered spouse can be used for. Response, or garbage cans. Or that, or garbage cans. Response, Mr. Beck, Your Honor, I'm fine. Essentially, I'm parroting what the deposition was taken by Dr. Brennan and by the state, so this is deemed to be an appropriate statement. I can move on. Okay, I'll sustain, and they're back. And by the way, if you notice there was a cut earlier, I stepped away because I was coughing too much. It's killing me. It's really bad. I hope it goes away after. I'm just gonna have to nap before the Lori Vallow trial because I want to do this. I still have a lot of at the benches left. Okay, and in this instance, this particular matter regarding the State v. Sarah Boone, where you approach about the possibility of doing an assessment as to Sarah Boone. Objection, relevance, approach. My understanding is he is not rendering any other opinions. Mr. Beck, right. So what does it matter or not he was approached? Mr. Beck, I believe the fact that he did not believe there was adequate time given the 30 days were available to an appropriate assessment of the patient, in this instance Sarah Boone, and is going to be utilized by the defense to establish that the expert testimony of Dr. Harper should be deemed more reliable than the testimony of somebody who only appeared one time in a series of tests and has nothing to do more. Anything further? Mr. J, I think it's irrelevant that he's approached and declined, and then also I'm going to preemptively object that since the rules only allow my expert to evaluate her once. The court, I'm going to sustain the objection, not only as to the second portion, but as to the first. The fact that he was asked and couldn't do it within 30 days is irrelevant to any opinion that he's offering. Mr. Owens, he's allowed to express what is necessary for him in his professional opinion to express an opinion, what he would need, what data he would need, what assessment, how many times, how much he would need before he could give his professional opinion. I think he can testify about that. I would need several sessions with the client. The court, but that's not the question that's being asked. The question being asked right now is where you approach to serve as an expert and opine specifically as it relates to Miss Boone. That's my takeaway from the question. Mr. Beck, I can rephrase the court. So if you want to do that way, it's a different kitty. That's not what's performing right now. He loves to say different kitty. Mr. Beck, I'll rephrase the question. Okay, objection sustained. I would object under the local administrative order. There's only supposed to be one lawyer per witness, and now I'm combating two lawyers. Oh boy. Okay. General rule is it's one voice, so whoever is going to be directing that witness, I need to hear for evidentiary purposes moving forward. That's fine. Thank you. I'm going to sustain the objection, but you can rephrase it. So they rephrase it. And the question at this point is, and I understand your answers today, and I'm not saying they were different the other day, but I understand you to say that it's very important to do a comprehensive evaluation at the full picture of what is going on in that perceived battered spouse mind, correct? Your Honor, maybe approach? Yes. Legal grounds of the objection, Mr. Beck. Your Honor, I object to the grounds this is the very area the state objected to are going into. I want to ask whether or not the court's opinion of whether or not they're in fact open the doors to the nature of the type of work that he would do and his inability to do it in this case because he was not afforded the time or the opportunity, so I think the state has opened the door. Response, Mr. J says, I'm not going anywhere near asking him why he didn't do it. He went into great detail about why it's important to assess the credibility of all the evidence. The court, didn't you talk about collateral sources, the 911 calls, and the witness statements, Mr. Beck? In a general context, not a specific context, as the state is attempting to do here. And because they are essentially positing these questions in a hypothetical phase, they, I believe, have opened the door for our side to describe what this individual was contacted and identified and that he could. The court, That's not my takeaway from the state's question. The state's question was, you want to have a comprehensive review, is what he talked about on direct. Mr. Beck. Okay, but I want to ask the question whether or not he could accomplish that review in the time he was afforded to him and why he did not do it. The court, as to opening the door, I don't see it because it specifically testified on direct as to what we'll be looking for in rendering an opinion, and certainly that's fodder for cross-examination, sure. Now I'm going to say right now and foreclose the opening door. Let's see where Mr. J's questions go, but I do find it's fair game for cross-examination, so the objection is overruled. Let's see here. Defense would rest. He can be excused and approach. So, talk of a break. We've only got one lay witness out there, and they got the phone extraction expert who's going to identify 2 photographs that we want, 2 videos that we want to play. But do you want to take a break first? Taking a lunch because Miss Walker was an elderly person that didn't want to come. I've got her. Her daughter, who's the primary caregiver, is the principal, and they're supposed to be here at 1. Mr. J, I'm okay with video with her if that's what you want to do. Video, okay? Mr. J, yeah. After taking deposition, you're now reversing your objection to consent, Mr. Owens. I'm going to have her at 1, so we've got somebody that's going to bring a wheelchair somewhere. So Mr. J at the last minute, after actually getting to speak to the witness, was going to let her be remote, but it was too late, basically. Well, if we're going to call her at 1, I'll get the deputies to remove the chair from the box because there's an on-ramp for her to get into the back where I come up. That back door opens for a wheelchair to come in. And then they go into open court. So basically, the only reason that woman had to come in was because Mr. J and his team were slow, right? Not Mr. J, Mr. Owens. Mr. J was okay with it once they had information about the woman and what she's going to testify to. Let's see here. Another approach. Lunch break. It's just lunch break. And we have an approach. I just called Dr. Harper. She didn't answer the phone, but sometimes I communicate her by text. I'm going to just text her. I don't know if... Man, she was causing issues, wasn't she? I'm just going to text her. I don't know if she's... They made her last night, the hotel room. The Hilton is split into 2 types of room, like home to home and then Hilton. They put her in the more expensive one. JAC doesn't cover that, so she had to move this morning to the other one. So I don't know what her status is, but I'm going to text her. Just text her and tell her to be here at 1:30. Mr. Henderson, yes, sir. Yes, Judge. I know you say that 3.6F. I'm going to be setting 3.6G to non-deadly because under certain circumstances, they both have to be read. The court, whatever instruction you want, please send. Okay, and we're back to open court. What is this? Oh, I remember this. This is with the older woman, the 81-year-old. During the occasions you had interacted with Miss Boone, how did you treat her? Objection, relevance, nice lady, overruled, nice to me. Mr. Beck, did she ever act uppity? Objection, relevance, overruled. Mr. Beck, did she ever treat you in an uppity manner? What do you mean, sir? Did she ever look down on you as a person? Oh, no. Did she ever treat you with disrespect? No. Judge, I'm going to object. This is character evidence sustained. Mr. Beck wants to approach, and they approach. Yes, sir. That was in direct response to the state having requested of Dr. Brandon as to whether or not there were signs of grandiosity that were presented by the hypothetical individual during the course of her life or any circumstances or refuting any sense that the state may have left with the jury that Sarah Boone is grandiose. Grandiose or narcissistic? Yeah, you definitely made sure no one thinks she's that. Court response. Judge, it's completely inappropriate to be asking how she treated Miss Walker. What the doctor said clearly during the testimony, though someone can be very nice in one situation, be very different in a different situation, so it doesn't provide any relevance to the relationship between Sarah Boone and Mr. Torres, which is what the state's evidence is about. The court, what's your response to that, Mr. Beck? Well, I think that's not what his testimony was. His testimony was as a part of the collaborative process of evaluating or assessing an individual, you have to look at their interaction with other individuals. Unless the objection is more, I believe the state's objection is character. So that response goes more of relevancy as to why, but what's your response to character? Mr. Beck, and I'm out of energy drink. I'm not getting another one. It is 5:42 a.m. Well, one character has been called into question by the state. The cross-examination state witness has been called into question as a result of the cross-examination of Dr. Brannon. The character of this witness or the character of the defendant has been called into question. This was an opportunity of the defense to refute the presumption by describing or at least giving the jury some sense of what kind of individual they are about to judge. Anything else? No, Your Honor. Mr. J, that's a misstatement of how the evidence works. They called an expert witness. They're the ones that opened the door to Miss Boone's mental health. They are attributing her actions on February 23rd, 2020 to a stress disorder. What the experts have to consider in evaluating the credibility of the person, in this case, the patient-client, relaying information to them of things what Dr. Brannon testified to and what Dr. Harper will testify to. Whether they're consuming alcohol, whether they have narcissistic personality disorder. So what's relevant is what Dr. Harper's perception is of the evidence that she reviewed, and that evidence is going to be largely based on 8 different meetings with Miss Boone. So how Miss Boone goes out in the world and interacts with Miss Walker and anyone else isn't relevant because that's not something Dr. Harper considered. They did good. The state did good, I think, at the bench. It feels good. I'm not a lawyer, but it feels like they know what they're pushing for, you know? I want to give them the props for that. Anything else? No, Your Honor. I think your argument has been made. The court, okay, I'm going to sustain the objections, both as to character and the extent. So now, we move on. This is before the defense's next witness. I tried to call her again unsuccessfully, but that's last. She told me 1:30. It's still 1:28. Dr. Harper? I know, but I texted Dr. Harper. The court wants you here at 12 a.m. to testify, 12 a to testify at 1:30. That was seen at 1:07. Okay. And I said just now, Dr. Harper, the judge is ready for you to testify now, so come to courtroom 12A, please. And then received, it's a little walk, is what she said. It's a little walk, so she's walking across. All right, she's walking over. Can we take a short break? Either that or we're going to let them sit here in silence. So I say we give them the break. That's awkward for everyone. So let's just tell them we're waiting on a witness. As soon as she gets here, we're going to be ready to rock and roll. All right. Did you consider Miss Boone's upbringing and forming any opinions? I did. Can you tell us a little bit about that? Yes. So of her history, I found it pertinent that she was raised with objection, conduit, 704, approach. Mr. Owens, I'm sorry. The court, she can't be a Mr. J, conduit. The court, gateway to inadmissible hearsay. Mr. Owens, in terms of the court, anything that Miss Boone said to her, the question pertains to Mr. Owens, in terms of what her father passed away when she was high school. The court, and if she's going to be eliciting statements that were provided by the defendant to her, that's inadmissible hearsay. Mr. Owens, what about the materials she may have been provided in writing? What about that? Records and whatnot. The court, that's not pending before me right now. Right now, my understanding is she's going to be testifying to a specific statement that Miss Boone has made. And 90.704 prohibits that, so the objection is sustained. She can revisit another way, but the question is phrased right now is, Mr. Owens, I don't know how, but I'll try. Okay. And we have, what had she been diagnosed with prior to you getting involved? And here we go. We're back at 704 conduit, objection from Mr. J. Another one. Mr. Owens, I didn't realize this was an objectionable issue that she had previously diagnosed. I thought it was going to come out either. I thought it came out with Dr. Brannon, but I thought for sure it's going to come out with Dr. Warner and some of the opinions she expressed, because I know she took deposition and she said Dr. Warner said, yeah, I believe with the previous diagnosis that she suffers from anxiety or some anxiety disorder. And so I thought the experts, and of course they want to form their own opinions, but they like to rely on the history of experts. The court, sure. Mr. Owens, so that was the reason for asking the question. I didn't know it was inappropriate to ask. The court, if you're asking her to rely and testify specifically to something that's inadmissible as to a prior diagnosis, 704 prohibits that from happening. Mr. Owens, I understand. The court, and that's what I'm taking the state's objection to be. Mr. J, yes, it's inappropriate for exploration or cross-examination. Inadmissible evidence can certainly come into it if it's relied upon by the expert during cross-examination, and it's certainly, I think, an expert, a forensic psychologist or psychiatrist would testify. It hasn't happened here yet, but I understand that it could, and I'm not objecting, but this is the sort of thing that usually rely upon. Like, I'm a psychologist, yeah, it's within the course of my practice, normally rely on other psychologists' diagnoses. The court, we just can't say what those diagnoses are. Mr. J, unless it's admitted into evidence already, and my understanding is that they're not doing that. A handful of pages, but I still haven't been provided them. But it's going to come out in the cross. It's just, I think, under 90.704, and according to Professor Herdart, page 954 and 955 of the 2024 edition, it's for me to bring out. The court, I mean, he's correct. It's Mr. Owens. I've got the 23 edition, Judge. I don't have the 24. Well, you know what, Mr. Owens? You should probably get the new book. But there's no statutory change to 9074, and some time, Mr. J is correct that on cross-examination, he's allowed to explore the basis of the opinion and go into those out-of-court statements. You, as a proponent of the opinion, unless you establish the inverse 403 test, is not admissible. Mr. Owens, I've been educated. I mean, listen, Monday comes before Tuesday. Objection sustained, and we're back in open court. Let's go to the next one. Here we have a question. Do some people with this syndrome disassociate? Objection, relevance, approach. Mr. J, we're in about 3 or 4 things. We're just asking about people in general. My understanding of discovery is that it does not. None of these apply to the defendant. And if it does, that should probably be in the question. The court, does disassociation apply to Ms. Boone? Because if I understand correctly, that's what we're talking about. Mr. Owens, disassociation is battered woman. Is it? They develop a defense mechanism of being to psychologically detach from their body during a traumatic experience. The court overruled the objection, so I mean, okay. Now we have talk of constant fear. That's correct. Now the abusive partner, the abuser, part of the abuse would be hitting, kicking, punching, choking, burning, and biting. Judge, I'm going to object to the relevance at this point. Approach, and we're at the bench. Yes, sir. Again, we're going into things that aren't in evidence. There's no biting alleged. If he wants to ask hypothetical things that are in evidence, then that's acceptable. But again, we've been down this road for a few minutes now, and they're not being asked in the form of a hypothetical, and there's no evidence in the case thus far that these like body disassociation or anything that she said. Response. Judge, she's testifying as an expert in that field of post-traumatic stress tied to the subset of battered spouse syndrome. What people will experience, and there's been testimony from Sarah Boone about all she experienced. The court, I don't recall biting. Mr. Owens, I don't think there was any of that either, but I'm asking questions about generally, what do you look for, what do you find? The court, the question that was just asked was specific things, kicking, fighting, biting. Mr. Owens, yeah, that's a general question. That's not specific to Sarah Boone. I didn't ask if Sarah Boone had been bit, but I know she's been burned, I know she's been choked, I know she's been punched, I know she's been kicked, I know she's been hit. Okay, I think further, Mr. J, these things need to be asked in a form of hypothetical and need to be based on facts and evidence. Okay, I'm going to find that it's relevant. What's your response to the improper form of the question, Mr. Owens? I don't know what he means by that. Improper form, I can ask, are these acts, are they committed by an abusive partner that are common too? If you want to ask what those acts to me be acceptable, I don't think it's leading for me to ask is hitting a common. I would agree with that. I'll break it down. I'm going to allow you to re-ask and revisit another way. All right, so we revisit. And here we are at the next approach. All right, the question is, all right, specifically, when it comes to affirmative defense, such as battered spouse evidence and insanity, what is your understanding of your expertise? What is my understanding of the issue? Is it judge, the question, legal objection, objection, legal grounds? He asked the question about battered spouse insanity. Approach, what are the legal grounds of the objection? It's a compound question. He asked the question was asking related to sanity and battered spouse syndrome, and I think that should be split up. Response, if any, perhaps I used the wrong disjunctive or because they're both affirmative defenses. I'll move on. You can rephrase it. 1 second. And we're back. Sorry if I cough without muting. It's because it's coming on real quick. As I said, not feeling great. And you saw in her police interview that she swore in her life of her son that she was telling the truth. Mr. Owens, judge. Yes, object, approach. Legal objection, that's an inaccurate characterization of the facts. We'll have to rewatch the video, but at the end of the video, she swears on her son's life that it was not intentional, that she did not cause the death. Mr. J, I'll rephrase. Objection sustained, you can rephrase. And they just say, she swore on her son's life that it was not intentional. Big change, guys. And then they object again. Legal objection, Mr. Owens, same thing. I did not end up killing George Torres. That was never said by her. What she was saying was his death was unintentional. That's what she was implying, not that she didn't kill George Torres. I would ask, response, the quote was, I promise you on Lucas's life that was not intentional, referring to the death she caused. The court, I understand the reference, but of the statement in particular is what she was swearing on. Let's keep it in line what it was. You can make an argument with that later. Mr. Owen, judge, I'd ask the last question be stricken by him because it's not in the transcript. That's fine. So the objection sustained, and the question was stricken. And here we have question. You didn't review the phone text messages extracted from the device, correct? I did not. Did you review any records from the jail? No. And Mr. Owens wants to approach. He asked that in a way to try to impeach her. That's something that she should have looked at when she didn't, and we have an issue about that, so I think it's improper for him to ask that question. Response, Mr. J says, I'm not following. And the court asks, is it your objection as to the lack of review of the Orange County jail records or jail records in general, using that terminology, or is it an objection as to what she did not review? Mr. Owens, I think he's implying first, what all did she review? Then he went into the you didn't consider this. When it went to jail records, he said records, but really it meant jail medical records that we have an issue on. I don't know if you remember it earlier. When you're referencing to, excuse me, this is a question directed to Mr. J. Mr. J, when you're referencing to the jail records, are you referring to anything in regard to Miss Boone's jail records? Yes. The court, because they have concerns about that. I know she's enlisted and she's being incarcerated, but I'm trying to avoid any prejudice with regard to that. Mr. J, right. I'm just asking if you reviewed any treatment records, but Miss Boone is the one that said that. Pause again. We mentioned this in another previous sidebar. Sarah's the one that let it out of the bag that she was in jail. Court, I know that, but as specific as to Orange County jail medical records, I can be specific. Okay, let's be specific with regards to your objection regarding Mr. J inquiring of these things. We can take it up on redirect if whether or not it's need to look at these things. Mr. Owens, didn't we have an issue where we agreed to not pursue the medical records? I thought we were attempting to get them, and the defense, I think, finally got them or given them right before we were about to pick the jury, and Mr. J complained that it was too late in the game. He was going to have to take time to review all the records over the weekend during his private personal time, and had asked, I think, maybe to reduce them down. I can't remember. The court. There were 382 pages. This looks like it's a Item 6 of Defendant's Fifth Amendment Reciprocal Discovery Exhibit List, certified medical records from the Orange County Jail, not yet released by the defense. The objection was filed. My notes reflect that 382 pages were provided on October 17th of the state, and I think that, Mr. J, that would have been after jury selection. Court, I think it was during. Oh, it was during? It was during. I don't know that we have finalized because I think it was delivered to them in the morning on the USB, potentially on the 17th, because that was last week, Thursday. Mr. Owens, it's starting to all blend together. Isn't that right? The court, my only notes are something about an intake screen on page 135 to 138. So we had to discuss what particular pages they might seek to introduce. They were looking to introduce. What I'm asking is, did she rely upon records that are routinely relied upon by experts in her field, which include diagnoses? I totally get that. Mr. Owens, it's the whole reason I wanted the records is because I wanted her to review them. This very question would not be asked. You didn't review these records. You should have done that. That's why we got the information as soon as we could. When we got her from the jail, it was during jury selection, which was 4 days. I think it was on the 3rd day. We hadn't sworn the jury yet. We got them immediately. We gave it to him, and he complained because there were so many pages. He wanted them pared down. Eventually, we just agreed to stipulate that we wouldn't use them, but that was for the purpose of admitting them into evidence. Mr. Owens, I know. Now he's trying to use them against me, and I was doing him a favor. That's comical. Mr. J had reviewed all the records. While we were discussing what was going to be admitted into evidence, correct, I agree with Mr. J. I'm just going to be a colleague, and now he's using it again. I was just trying to be a colleague, and now he's using it against me. He's using my client against me, Judge. The court. But the discovery, the exhibit list was solely as what was going to be sought to be entered into evidence at that time, whether it was you, the whole kitty of everything that may be admitted. I agree with you that Mr. J had an issue with 382 pages. Let's take the time frame out of it and say there were 382 pages, and the issue was calling it down. The only note I have is an intake screen from page 135 through 138. I don't have any other, but I recall the defense at that time, after discussing, had abandoned attempting to move those into evidence. Whether or not she reviewed them or not, I think is fair game for cross-examination. Mr. Owens, wasn't there talk about whether she could review those, because I was going to send them to her? You remember, Judge, I was going to send them to her, and you made a ruling. So I said I'm not. I'm going to stop sending them to her, and I think I showed you an email or showed you a text message that I had sent to her. It's on my phone, where I said, do not review, in bold capital letters, do not review the medical records. The court, if you want to go back and look at your phone and see if you can find that, I just can't remember. Do not look or consider the jail medical records of Sarah Boone. That was October 17th at 1:06 p.m. Mr. J, I can't remember the difference between the discovery issue as far as coming into evidence or what she reviewed. The court, here's what I'm going to do. I'll give you the opportunity to go back and confirm this is what she hasn't relied on, so you're not ending in a weird point, and I'll leave that to your discretion, but I'll sustain the objection with regard to the Orange County jail records. So let's just see how this ended. She did not review Sarah Boone's stuff. I remember this being like a big thing where people were like, why wouldn't their expert actually review her records? And it was because Owens got it to the state late, basically. My understanding. State says it didn't contrast the autopsy photos or report to you. Approach. Legal grounds of the objection. Judge, she's a forensic psychologist. She's not a pathologist where she could reconstruct, well, the injuries here are consistent with a bat being poked versus a bat being swirled. That's what he's asking. Mr. J, I'll move on. I've got another question. They just move on. Let's see here. This is after a witness. We don't have any more witnesses left. We've got some arguments to make about introducing court record, taking judicial notice as it relates to the last question. How George Torres violated a no contact order. Got it. I think that probably should be made outside the jury, so they separate with the jury. And here we have another one. My opinion was that she did not give me enough information to diagnose her with post-traumatic stress disorder at the time I evaluated her at the jail. And specifically talking about that, Judge, can we approach the bench? And Mr. Owens, I don't know if it's a legal objection. That's always a good sign. It's always a good sign. But Dr. Werner evaluated Sarah Boone at the Orange County Jail on October 2nd. 2 days later, on October 4th, I took her deposition on several of the issues she said. I have not informed opinion as to whether or not she suffers from this or that. A couple of them, she said she was convinced that she suffers from alcohol abuse syndrome. But on other issues like post-traumatic stress, issues like battered spouse, I think a couple more issues, she said I would need more time to reflect. Since I just saw her 2 days ago, I need more time to review my notes. She said it will probably be a couple more hours need to spend on it. I said, well, we can agree between the lawyers that if she forms any opinions that the defense will be notified. I remember this being talked about in open court after this. I was not notified. The court, okay, that she formed that opinion. Mr. J says, my expected answer from her is that based on what Sarah Boone said at the events, that battered spouse is inapplicable because Mr. Torres and her were laughing that it was her who decided to get angry and would not let him out of the suitcase. That's all I'm going to establish with her. Mr. Owen says, I understand, but we had an agreement that if she changed her opinion, she would let me know, and we agreed she could retake the deposition. Court, give me a moment. It was an agreement, Judge. I'll show. That's what I'm pulling up right now. I've mentioned on several pages. It's more than you have specific pages. They go into the page number. This pertains to adjustment disorder. Well, it keeps going, Judge. Like I said, several pages. I'm on 41. 41, line 15, this is Dr. Warner saying, I'm assuming that's Sarah Boone. She has generalized anxiety disorder. I'm saying I want to review more. I think it's more of an adjustment disorder to being in the correctional setting now, the stressors that she's under right now, as opposed to general anxiety. Mr. J on line 11 then states, okay, so on this topic, if something new comes up, we can address it, but if you have other opinions to oppose her on, we suggest we go on. Mr. Owens, I agree. Dr. Werner, just let the state attorney know. I know you may, we are short on time. If you do review your notes over the weekend and whatnot to formulate other opinions, just let the state attorney know and we'll address it. Witness says absolutely. Try not to read a bunch of things that don't need to be read. The court, but the answer is no. Question line 13, page 46, but you don't believe that she suffers from post-traumatic stress disorder in your opinion? No. Mr. Owen then says, look at line 19. Court, I have to go through my notes, back to my notes as she fully met the criteria. I'm sorry, hit the wrong button. Line 17, can you explain why you don't think she suffers from? No, I didn't say one way or the other. I have to look back through my notes for that. It's something that you may in the future give an opinion about after some more time reflecting on your notes. I may, okay. Mr. Owen says 25. That's something you'll let me know about if that changes. Yes, okay. And then just for the record, this 46, line 25 through 47, lines 1 through 2 of the deposition of Ms. Werner, Dr. Werner. She did go all the way through on several. Okay, well, the only issue right now is PTSD, the opinion of PTSD. So what's your What I don't hear is a legal objection. And that's a common thing, right, with Mr. Owens. There were a lot of issues of objection, and they didn't know what they were doing. A lot of issues of case law, and then Owens didn't know how to respond. Mr. Owens, we had agreed. I don't know if I can find the right page, but I agreed to retake a short deposition. If you give me some time, I can find it, where Mr. J said I will agree to a short deposition of her opinion changes between now and the time of trial. And I relied on that because she would not be pinned down. If you give me a few minutes, I can find it. You want me to let the jury out. The court says, I think we're going to have to do it at this point. Mr. J, have anything to add? Just for own. Okay, so this is where they kick the jury out. And Mr. J says, again, what I'm trying to establish as witnesses, regardless of whether Sarah Boone had PTSD, A, B, C, D, D, X, Y, or Z, or anything else, that it doesn't matter on what Miss Boone specifically told her about the incident. That's all I'm trying to get out. The answers were divergent from the question. I don't think I'm violating any agreement because her opinion has not changed. I was only able to speak to her for 2 minutes yesterday. Just asked her about the specifics of does this apply, given what she said at the event. That's not something new from the deposition. Okay, let me remove the jury for a moment. So they removed the jury, and we saw this publicly play out. Trying to find what this one's about. Anyway, it's striking something. I disagree. We're talking about, I'm going to be able to use it to impeach her with statements like that she made in deposition versus the statement she made today. Referring to the correct response, which response is that. The last question I asked in front of the jury, she gave a non-responsive answer. What was your opinion? My opinion was she did not give enough information to diagnose her with PTSD at the time of evaluating her at the jail. Mr. J says, well, the question before that is what's relevant. Court, what else did you rely upon? Mr. J, no. I basically asked the same thing that my proffered questioning was asking. Then she gave her non-responsive answer that caused all of this. I'm going to overrule your request. The question was your opinion, and the answer to the last question is what was your opinion. So that got overruled. I don't remember exactly what that was. When I trolled back, and I think it was involving the whole argument about her opinion, and Mr. J wanted it all struck anyway. All right, so here we go. The answer to the whole part, she's describing the part about playing hide and seek, and they're having a good time, and they're laughing. When he got in the suitcase, when she found him, they were enjoying themselves. She zipped him up, and they were laughing, having a good time. All of that isn't consistent with her having a feeling of him, an imminent fear, that there was an imminent risk of harm. Mr. Owens, I'm going to object. Can we approach? And the court asked for legal grounds, and Mr. Owens says, Judge, I don't object to her expressing. The court, what are the legal grounds of your objection? You just said I object. What are the legal grounds? I like how this has happened at the bench, too. It's an improper response to a question in which the ultimate issue of fact is being asked by the prosecutor. It's an improper answer to that. The ultimate issue of fact is for the jury, not for her. Response, Mr. J is no different than an expert saying insanity applies or doesn't apply. It's their expert opinion on that portion of the law, and that's permissible. Mr. Owens, I don't believe that. The court, just because, even assuming that the answer embraces an ultimate issue, that doesn't mean it's objectionable. It's not saying she committed homicide. It's not saying that she's negligent. It's not saying that she's punitive. It didn't go to any of those specific elements. Mr. Owens, she's not expressing a medical opinion. She's expressing a scientific opinion. She's not expressing a scientific opinion. She's expressing opinion as to whether or not her behavior, her conduct, her statements constitute an imminent threat. That is the providence of the jury. Court, she didn't say that. Mr. Owens, yes, she did. Mr. J, this is the exact same thing as a doctor saying somebody didn't appreciate the legal consequences or did. There's an interaction of the intersection of law and psychiatry when this testimony comes in, and it's not objectionable. Mr. Owens, think about what she said. She's ultimately telling the jury there was not an imminent threat. That's a question for the court. Essentially telling the jury and telling the jury are two different things. What specifically did she say, Mr. J? Mr. Owens, she mentioned, I do not. We can have the court reporter read it back, but it's a critical issue, Judge, about the ultimate issue of fact, whether the psychologist, based on a history of my client, gave to her 4.5 years after this event, and whether or not I believe as an expert know the defense cannot apply because she did not perceive an imminent threat. But the question didn't ask about a defense unless I missed something. Mr. J, I agree. There's absolutely no different than if an expert. Mr. Owens interrupts. I think we need to reread the question and reread her answer. This is a critical issue about guilt and innocence that she is expressing. Coughing's killing me. Are you able to reread it for me? Judge, I'm going to ask it to be done outside the presence of the jury to the extent possible. If you have Madam Court come up here and do that, I will do that. Court reporter, I'd have to disconnect. The court, it's going to be disconnect everything. Okay, all right, I'll take them out. Jury exited. I don't. Question was read and asked back. I don't know if this was in front of the jury. I think this was. I'll get to the final result, just in case it wasn't. I'm pretty sure this was all public, because the jury was gone. The objection got overruled. That's what I thought. I thought I remembered that being a public discussion. You said you considered some text messages from Sarah Boone's phone. I reviewed them, correct. Would it be fair to say that those text messages are not necessarily overly relevant? Mr. J, objection, maybe approach, yes. Mr. J says, outside of scope of what she reviewed for her opinions that were expressed today, the opinion she expressed today was based on the evaluation of Miss Boone. Response. Mr. Owen, judge. She considered everything that was given to her. She reviewed that. Everything that was given to her before she went to the jail. And had interviewed Sarah Boone. So she had that in her mind when she interviewed her, Sarah Boone. Okay, so there was twice talk of Sarah Boone. And her opinions are tied to the paperwork that she was given to her. That's standard operating procedure of any expert in this field who relies on collateral sources as well as the assessment made of the patient. Coordinating response. Mr. J, may I voir dire the witness then and ask her to this inform your opinion what you did express the applicability of BSS and PTSD to the facts of the case. But it was provided to her, correct? Right, but she did not express that she relied on it. Court, yeah, I'll allow you to voir dire the witness. Go ahead. And there's the voir dire in open court. So, continue on. You read all the text messages, correct? And you are going to express some opinions here today, are you not, correct? You're going to express some opinions about narcissism. Mr. J, objection, approach. Yeah. Mr. J, this is outside the scope of direct. I didn't ask her about the narcissism or any of those things. If you want to recall my witness, they can, but this is way outside the scope of cross. Response, judges and expert witness were given the wide latitude to cross-examine. Can't believe you're trying to limit. Court, but she didn't offer any opinions on narcissism. So what facts or consequences make it more or less probable? Even if it may be in the deposition, what does it matter for the purpose of today based on what she's rendered opinions on? Mr. Owens, I'm allowed to question her on any of the opinions she may have about my client. Just because I specifically only want to ask her about one opinion that she has about that issue does not limit me from asking an expert witness in psychiatry about other conditions that may or may not suffer from as it relates to the ultimate issue that she's expressing, asking the jury, deciding on an issue of self-defense, battered spouse syndrome, whether she acted appropriately under circumstances. The court, any further? Mr. J, judge, the reason the state went to the narcissistic personality traits that Dr. Harper expressed that she has, and the reason we had Dr. Brandon explain all those things is because it was specifically relates to the credibility of the patient or the client informing the doctor and goes to the weight and credibility of the opinion that they render. So we got into the alcoholism with, that's what we've gotten to the narcissism with, that's all those things were asked and answered by experts as to directly relating to the credibility of the historian giving the information. So if he wants to impeach his client's statements by having her express that she opines that she had narcissistic personality tendencies, that's on them, but I'm not addressing that. Mr. J, that's not the basis of her opinion. Mr. Owens, Dr. Brandon testified, Dr. Harper testified, it's standard operating procedure to rely on all those. The court, that's not the issue. The issue right now is whether or not it's outside the scope. That opinion was not offered. I'm going to overrule the objection, but I find it's really limited relevance based on what her opinions were, but I'm going to allow you to proceed on it. Mr. Owens will judge if I'm not allowed to explore. That's not what I said. Her opinions are not what I said. What I said was I'm going to allow you to do it, but she didn't offer those opinions. Mr. Owens, James Owens wins here and still causes problems. I understand that I'm allowed to cross-examine her that she didn't find certain diagnoses. The court, the only issue before me right now is an opinion on narcissism. The state's objection has not been offered. It's not relevant. I'm going to overrule their objection, but just be mindful that they're not offering any of these opinions. Well, it goes to the other objection about whether I can go into the other evidence she relied upon in expressing her opinion as it relates to Sarah Boone, as she relied upon collateral sources, including, that's not in front of me right now, that issue is not in front of me. There's been no objection to that at this point in time. The only objection was to the text message. It was not a basis. Can we go ahead and talk about it? Sure, go ahead. Well, I think this all started when I was asking the expert Dr. Werner about Sarah being cell phone records. I believe the state attorney provided her. I'm not sure if it was. I'm pretty sure it was text messages from that cell phone. I believe the testimony comes from Dr. Werner is going to say that the reason this comes up is I know they're going to introduce a bunch of text messages. The court, what are you trying to get at? Judge, I guess. Court. If you're getting into the basis of her opinion that was relied upon, you're absolutely allowed to do that, but you have to understand, based on what opinions were elicited during direct and what the court's heard, none of that mattered for the purposes of the opinion she testified for today. If you want to do that, I'm not going to foreclose you from doing it. It's your decision. Mr. Owens, they're going to object to me asking about all that information, all the evidence. I'm going to get into medical records. The court, Mr. Owens, I'm going to get into the advent records. The court, if that was the basis for opinion, you're allowed to explore it. That's all I'm saying. Are you going to be objecting to, Mr. J, the testimony that she gave us was outside materials, were absolutely irrelevant to the opinion she gave? The court, I understand that, Mr. J, and the court interrupts. I understand that. If he wants to explore it, he can explore it. It may not be beneficial. I don't know. Mr. Owens, I need a ruling judge, because if we're going to rule that I can explore that, the court, I've already ruled it, sir. I said you can explore it. I said you can. Okay, but he won't get out of his own way. The court, problem is I don't know what the utility of it's going to be because of the limited scope of the opinions. She didn't rely on anything of the stuff in informing her opinion as what she's done today. If you want to do that, you can do that. I'm not going to say no. Mr. Owens, okay. His suggestion was, in my thing, I'm going to get into medical records of Sarah Boone. I'm going to get into specific notes about those medical records relating to her Baker Acts. Those of her Baker Acts. Multiple Baker Acts. Was that known? I think that was known. Mr. Owens, it's going to be objected to because it's not relied upon, and I'm going to need to call Dr. Werner as my own witness as an adverse witness. Court, okay, wait a second here. Okay, did she rely on medical records? Mr. J, she was provided them, but her direct testimony that we all just heard together, it did not inform her opinion that BSS and PTSD do not apply to the facts of this case. The court, if you're able to tie it that she relied on them somehow, we can address it. It doesn't address any issue of hearsay or a 704 issue. Mr. J, well, experts, just like I did, the court, on cross-examination, you're allowed to go into it. Mr. J, if an expert relies upon what she testified today, she did not rely upon it. So each time he brings up a new piece of evidence, I'm going to voir dire her and ask her if that information was one of the opinions she gave. Mr. Owens, Judge Cranick. Yes, sir. What I'm getting at, let's not bicker and fight about this. If he's taking a position that he's going to object to everything, but he's not going to if I call her as my own witness, I can treat her as an adverse. Court, no, it's the same. Witness, let's do it. It's the same problem. Mr. J, you can't. I think I'm allergic to bullshit. Like, Mr. J is being so clear. Mr. Owens won and won't get out of his own way. He's going to talk himself into not winning this issue. The court, but he's correct on that. 90.704 prohibits it. You're allowed to do it on cross, but the problem is there's not a basis for opinions of what was offered today, so 702 tells us what we need to know. How is it relevant for the purpose of her opinion of what was provided today? Yeah, I looked at those medical records, but they have nothing to do with that opinion I relied upon, I opined on today. Mr. Owens, it's not. That's not the issue. The issue is cross-examination, wide latitude is allowed, especially for an expert witness. The court, you're not answering my question. The opinion that was offered was, in my opinion, BSS and PTSD are not applicable based on what was reported to me. How do the medical records have anything to do with what is sufficient fact and data point that she relied upon to render that opinion? That's the first step. Mr. Owens, that's her opinion. I can expose her opinion as not reliable. I can expose that she admits that she suffered from battered spouse syndrome. I can expose her opinion that she suffered from alcohol use syndrome. I can expose her opinion that she suffers from an anxiety disorder or adjustment disorder. I can expose her opinion that she meets some criteria for narcissism. And she relied on those records in formulating that opinion as every expert does in the field. I'm granted wide latitude to go into all that, to express, to attempt to impeach, to show that she's biased. To show that she's the state's witness, and her only job is to try to help the state win their case. The court, I understand. I'll allow you to proceed, but you're going to take the answers as they come, Because if she keeps saying it had nothing to do with my opinion today, that's what you're going to be stuck with. I don't know what she's going to say, but I mean, the state's opinion was very truncated as to what they're offering her for. Mr. Owens, and from my position with the state attorney, is you're going to be objecting every time, and you suggested I call her as my own witness. I'm going to do that just to save some time because I don't want to get into this. I spent 10 minutes up here every few seconds. It would be better, I'll call her as my own witness. Anything else, Mr. J? Mr. J says, just so we understand the law, you can't get into inadmissible evidence on direct. The court, I know that. Mr. J, there's no basis for a surrebuttal case. The court, I'm not addressing surrebuttal at this point in time, but he's correct. 90.704 is going to prohibit her on cross-examination, or direct examination, from testifying directly to inadmissible evidence. Cross is a different kitty. He loves being a kitty. The court specifically addressed that. I'm going to allow you to do it, and you can object, Mr. J, and Mr. J, I'll just ask for voir dire. The court will address it as we go. You may proceed. Objection overruled. All of that. James Owens won like 5 sentences into that. Couldn't get out of his way. And what is this? Okay, and at the time you said you're not necessarily overly relevant to your examination. Did you say that? I don't recall specifically. I'll look at that. Mr. Owens, can I approach the witness? You may. I have it. May I voir dire? Just a moment. By Owens, you got it. I do. Page 14, my question at line 3. Your answer begins at line 5. You agree with that. Judge, permission to voir dire based on that. Let him finish. I'm going to ask another question about the text messages, Judge. You just said line 5, approach. The court. I asked her to refer to page 14, line 5, and have the depot in front of me. It says I was aware of them, but they're not necessarily overly relevant. That's correct. So what are we doing? If you're going to ask her to rely on that and ask her about text messages, you need to give her the opportunity to say this is what she said. All right, and then go back out. Here we go. Do you recall telling me that you don't understand medical issues, so to speak? They haven't been to medical school, but I wouldn't understand their medical knowledge. Look on page 22 of your deposition. Objection, collateral, approach. Mr. J, is collateral impeachment not a material issue? What's on line 2022? Judge, it goes to the basis. What line, sir? On 22, it starts at 7. Line 7 is distinguishing between psychiatrists and psychologists, overruled. Here we go. This is about whether they notified them or not about her change. They notice if she notified them about her change or not in their opinion. There we go. J, I didn't ask for any of his opinions. I don't see the relevance. Mr. J asked for the approach. Court asks, what are we doing, Mr. Owens? Mr. J, it's improper. The questions. Mr. Owens, she's making opinions here today in court. The court, there's another way to ask it. Mr. Owens, when she told me, the court, there's another way to ask it. Hey, this is the first time you've rendered this opinion. You did not render this opinion in your deposition. There's other ways of asking other than saying, hey, we agreed and you lied, or anything along those lines. Mr. Owens, she said some things in deposition that she would notify me or notify the state attorney if she had a change in any of those opinions. She failed to do that, Judge. The court, there was no change. There was no change. We've been over this. Judge, at the time, let me get the transcript. The court, Mr. Owens, I don't need to reread the deposition transcript you provided to me. I'm familiar with the portions that you're relying on. Mr. J, Judge, it's improper to him to ask the opinions that I did not and then cross-examine her on them. Had I wanted to get her opinions on these things, I would have sent her all these records that we have. I didn't want to delay the trial when she gave me the opinion that battered spouse syndrome didn't matter in this case. So I foregoed giving her any additional records so I could get valid opinions, and now he's being allowed to ask about these opinions and cross-examine them on her. It's improper. The question before the court is improper. That's pending right now. I find improper. That was a discovery issue that was remedied. It is not something that the jury needs to worry about. If you want to ask her questions about the formulation of that opinion that was provided, that wasn't provided at depot, today may be the first time it's going to be provided to you, fine. What we're not getting into, there was a promise and it gets complicated. I'm not going to do that. The objection is sustained. Okay, so this is when Owens talked about how the witness didn't know about Lenora Walker approach. It's collateral impeachment. It's not a material issue. What does this, her knowledge, and what is specifically the line 54? So it's line page 54. I started the question at 23. Where is the impeachment at? You see 54, I think Lenora Walker is the one who first developed. She responds, I'm not sure. Mr. Owen, she responds, I'm not sure. I've got the therapeutic treatise, which is the authority treatise on battered spouse syndrome. Right now, we're looking at impeachment. What's the impeachment? Well, what's the contradiction, Mr. Owens? It's that she didn't even recognize who the authoritative person was in the field of battered spouse syndrome, with Dr. Michael Brandon recognizing Dr. I think she spoke of it. I know he spoke of it in in his testimony. I think Dr. Harper mentioned Lenora Walker 3-step cycle for battered spouse syndrome, and she was not even sure she knew who Lenora Walker was. Okay, what's the impeachment? The impeachment is I'm going to ask her if she recognizes that an authoritative treatise. They spoke on it. She wasn't even sure of who Lenora Walker was. The court, no, I'm going to sustain that as collateral. And Mr. J says, while we're here, what's becoming obvious to me as we start asking about alcohol abuse disorder and narcissistic traits and all the things the state did not get her to opine on, this is essentially like him calling his own witness to impeach. That's improper impeachment under the evidence code. I can't call a witness just to try to impeach the witness in front of the jury. This is what he's doing on these news topics. He's bringing these topics up that the state didn't, and then impeaching her on them, and it's improper. Mr. Owen, judge. Court, I disagree with impeachment on them, but I'm going to agree with you on the collateral matter. I'm going to sustain the objection. But Mr. Owens wins sometimes. He just can't get out of his own way. So here, they ask if her opinion changed when it comes to battered spouse. No, not at all. Why is that? Because, again, the way that she... Objection, judge. Legal grounds? Well, her answer is legal grounds. Sorry about the coughing. It's bad. I would edit it all out, but I'm trying to get this out before the Lori Vallow stuff I have to cover. Because I'm going to have little sleep as it is. Asked and answer. She's going to rehash it again that battered spouse and post-traumatic stress do not apply because her conduct was not the one because her conduct was not one that she's facing. He responds, Mr. J, I'm asking her based on all the information that was just conveyed to the jury and all the questions and answers that was given that wasn't asked about in direct because it didn't happen. The objection is overruled as to asked and answered. What is this? Something being brought in. Mr. J wants to approach. Oh, it's about timing. Okay. This is about just sending them out. They didn't have time. We're getting close to the end, by the way. I think a lot of these are probably going to be short if it's about this stuff. Here's about another folder. It's about getting the evidence played. So it's very short. Juror has to leave. So they send him home. Or like, yeah, so. Well, so there we go. That's nothing. They're at the bench. What is this? Oh, it's about the courtyard incident. Members of the jury. So they sent out, except for the person who saw the courtyard incident. It was a domestic violence thing at the courtyard. Can the parties approach? And that's it. That's just them like, do we get rid of the juror? No. Okay. Oh, I went too far. Maybe. Nope. One more. This is about the text messages. Owner to Mom George, yay, getting in the shower, then out, bye-bye. Mom George to owner, judge, can we approach the vent? So Owen's approaching about the text. This is the problem that I tried to address at the beginning about having somebody else reading these texts. He's changing his tone during the reading of the text, which is what I thought he would probably try to do. I object. Any further? No, sir. Overruled. What is this one here? Mr. Owens wants to approach again. Judge, I understand they introduced the exhibit, a copy of the exhibit, which is 111 pages, but we do not know which ones he's going to cherry pick and read to the jury, so there needs to be some kind of instruction that explains that this happened. I think it's something that, like, out of 108 pages that are in the exhibit, the prosecutor elected to read these sections to the jury. These text messages are not all the ones on the phone. Those are highlighted, have been highlighted, selected to be read by the state attorney. Also, Sarah Boone and George Torres shared that phone. Some of the messages, maybe those of George Torres. The court, I'm a little hesitant. You're covering the microphone. I'm a little hesitant to give the second part that George Torres and Miss Boone shared the phone. That's me commenting on the evidence. I'm not allowed to do that. Mr. Owens, you agree they shared the phone. Mr. J, I think you're more than welcome to point that out in closing. I think they said it in the openings. The court, I'm inclined to do that. I'm not allowed to comment on the evidence. Okay, then I think one of the other instructions we're going to ask is the prosecutor jump pages. He went from page 4,324, which was July 26, 2019. Then he jumped to page 4,336 to August the 19th of 2019. As he was reading that, so the jury believed needs to understand that. Court, I'm disinclined to identify specific pages. Again, that's me commenting on the evidence. I'm not on board with something along with the lines of when Exhibit 21 was read, it was at page 108, and it's everything that's included, including those pictures and everything else, right? Mr. J, it's the videos, the movies as well, as which were published. Court, which was published yesterday. Okay. So what if I had something along the lines of the state has concluded their presentation of Exhibit 21. This is not inclusive of everything. The state identified certain portions for you, and that the entire exhibit will be back to you in the deliberation room for you to review. Does that work for you, sir? I trust your judgment. Mr. J, it sounds verbatim as what I said at the beginning. If it needs to come from the court, I don't have a problem with it. Court, I don't have a problem saying that. I'll do my best to remember what I just said. You want to write it down? Ask the judge to write it down. I want to write it down because I kind of just spit that off the top of my dome. Mr. Owens, and of course, Sarah Boone wanted me to let the judge know the context of all the read text messages by the state were not read in their entirety. I think she means maybe the thread of text messages is changing the understanding by not knowing the whole message. The state only selected what they wanted to hear, and it was not complete. She also objects by his tone, the way he was changing. It changed the understanding. Some were not read properly in the light or manner they were meant to be sent by the defendant. The cadence she's saying had a special cadence between each other, the other way they talked to each other, and by his tone, he was misrepresenting their cadence by him reading those to the jury. The court. I didn't see any heightened change in Mr. J's tone as he read the messages. Maybe Sarah wanted it all read in her baby voice. They were read in a flat manner. There was no emphasis on certain words or other. I thought it was read in a benign tone as best possible. As to the cadence of the conversation between Miss Boone and Mr. Torres, I can't speak to that. I don't know anybody who can speak to that other than Miss Boone. I don't find any issue in which the way the state delivered the readings of the instructions, the tone was flat, it was benign, there was no raising and lowering of pitch to any drama to the text messages that were highlighted, so I'm going to overrule the objection. Mr. Owens says, okay, my suggestion the jury is out. We can go ahead and announce that so Sarah Boone can hear it. I don't have a problem with that. I'm fine with that. It's fine. Let's go back to instructing. We'll sing along the lines of members of the jury. The state showed you portions of the exhibit. 21 is not the entire exhibit. The entire exhibit will send back to your laptop for review and deliberations. Perfect. Yes. Anything else to address? No, sir. Anything else, state? No. Thank you. And they go back to open court where they can baby Sarah Boone and let her know it's not happening the way she wants. Now they talk about timing again. I got something to, Mr. J. Is that us? Yeah, but I have something to go over with you. In my haste to print this out, I missed the second for us up there. If the parties are accountable for the copy of the jury, taking a permanent marker and excising it, yes, and reprinting everything. So this is just about removing something that was accidentally printed. Sarah. Oh, Sarah. Stupid. Sarah. That's my name. Don't wear it out. Sarah. I can't fucking breathe, babe. Seriously. That's what you do when you choke me. Sarah. Mr. Owens, can you ask the jury to go out? Video pause and at the bench. Mr. Owens says, please ask the jury to go out. She's weeping and crying. I'm going to ask for a mistrial if she's not allowed. If the jury is not allowed to go out. Hang on, Mr. Owens. Hang on. Mr. Cacciatore, I don't think we need to do that. Just give the opportunity to go over there and ask her to step out of the courtroom. Mr. Owens, hell no. She's bellying over, sobbing, crying. She's leaving. Judge, please let the jury out. She's leaving. Go out. They don't need to. That is highly prejudicial to my client for that happening in front of the jury. She's gone. Thank you. Anything else, Mr. Owens? Yeah, I don't know what else to do other than instruction, some kind of curative instruction, but I have to think about it. Okay, well, think about it. So you want me to do? Can we have the jury go out for a minute? No, I don't want to do that. Mr. Cacciatore, no, not the court. Not in the middle right now. Mr. Cacciatore, I mean, Mr. Owens, I should have asked, Judge. Probably my fault because I should have asked, because a lot of times the judge will say anybody in the audience is going to have an adverse reaction, yay or nay, sad, glad, whatever the case, going to show some kind of physical or audible reaction. You need to leave the courtroom now. Court, but I don't want to bring any more attention to it than is necessary at this point in time, so I'm hesitant to give the instruction to highlight it. I don't know if the jury saw it. I don't want to point it out that someone has left or anything along those lines. Mr. Owens, yeah, let's leave it alone. Okay, all right, as you wish. And they resume. I believe that was George Torres's mother crying, and then they tried to cause a mistrial later with it, argue a mistrial. He couldn't exert anything, ladies and gentlemen. He couldn't. George Torres couldn't even exert his arm out of the suitcase. How on earth could he have exerted a force so great to justify his "Judge, I object" approach? Mr. Owens, it's a misstatement of the facts. He could not exert his arm out of the suitcase. Court, it's argument. It's closing argument. Mr. Owens, that's a misstatement of the facts. The only testimony in this case is that he reached his hand out of the suitcase, correct? There's no testimony or evidence that he did not. Okay, hang on. Response? Mr. Cacciatore, an arm is not a hand, and your client gave several versions of events to include only fingers. So, the court, he's correct. There were different versions, as reported by the experts and by Miss Boone. Mr. Cacciatore, but there's been zero testimony that an arm never protruded from the suitcase. Court, response, if anything else? We all heard the testimony that his hand came out of the suitcase, right? Mr. Cacciatore, a hand is not an arm. The court, I agree. So I think in closing argument, there's a fact in the record for him to argue it, so your objection is overruled. They go back out to the closing. Oh my God, I remember this. Let me tell you how small it is. 7 miles away is a small town called Pace. In between that is a Walmart. Very small town. I didn't know what to expect coming down here to Orlando. Judge, relevance. Judge, I'm allowed to introduce the court. I'll give you a little bit more for intro, but we need to get into it. I'm going to get into it, but I wanted to say it's a small town, good people. We've been down here 3 weeks, didn't know what to expect. We've been surprised. Objection and proper argument. Mr. Owens' approach. Court, I'm a little worried about I didn't know what to expect. We've been treated very well, very hospitable by the people in the street, by the people in the court system. Okay, I'm just trying to explain that we're from a small town, didn't know what to expect here. We got here and pleasantly surprised with how we were treated. Mr. J, anything else? It's completely irrelevant. Court, I'm going to overrule. I'm going to give him the opportunity, but I don't want to belabor this for too long, okay? Thank you. Let's see here. Mr. Owen says, what's this here? Now, I'm going to do some reading, then I'm going to do some talking, but ultimately this is about justifying the use of force that is a legal defense in Florida. As citizens, the law is designed to protect us from defending ourselves, to protect us from a potential attack. And you are the only ones in this case, because Miss Boone, Sarah Boone was arrested, that's going to be able to look at this critically and objectively, not like the state attorney. Objection and proper argument overruled. Mr. Owens. Objectively, and the law in Florida gives you all the power and authority to do that. The state attorney can't make the decision. They can't make the decision. They can try to influence you, and they're going to talk about some of the things that they did here in this trial and some of the things they said. Judge, objection, maybe approach. Yes, Mr. J. I believe the court made it very clear they weren't going to be ad hominem attacks. That's exactly where we're starting. The court, where are we going, Mr. Owens? Judge, I can make comments on the state and the state's case and what evidence they presented. This is argument. I agree with you, but you're not going to have attacks on individual persons. That's my only point. Judge, he objects at everything. Everything he objects to. Everything. I can't speak to Mr. J and his objections, okay? He thinks he knows it all and objects to everything. This is my chance. And this is stop. That right there. That's an ad hominem attack that he objects to everything. He thinks he knows everything. If that's where you're going in your closing argument, I'm not going there, Judge, but you're doing it now. You're doing it right now. Mr. Owens is outside the presence of the jury. Court, I understand that, so I want to make sure that the line in the sand is remarkably clear. We're not going to have ad hominem attacks. If you want to attack the state's position, their evidence they provided, and that's sufficient for the burden of proof. I 100% agree with you, 100% fair game. But if I hear Mr. J or Mr. Cacciatore in an argument, we're gonna have to talk. Mr. J, a judge, I move to strike that Trey is trying to improperly influence you. The arguments have to be about the evidence and the influence from them. He's attacking the other party. Judge, what I'm saying is we're going to show the state's evidence, what they presented. The court, what I overruled objection on was the state is trying to influence you. Now, I'll let it slide because let me see where you're going with it. And I'm not going to sustain Mr. J's objection at this time, but let's not attack a person. You want to attack a position, you want to attack evidence, go ahead. We're not going to be attacking persons. Okay, thank you. And they're back in open court. What do we have here? And this is, oh God, this is almost immediate. Thank you, Judge. They got their side, their position. We've got our side. We're going to talk about that. We're going to talk about the justifiable use of deadly force and non-deadly force, but either way, however you rule, it still justifies her behavior and the result is not guilty. I don't believe there's anybody. Objection, improper argument, overruled. Mr. J, maybe approach? Yes, Mr. J is mad about the ruling. The court is it with the I don't believe there's anybody language. Mr. J, he's injecting his personal views. Mr. Owens, I haven't finished the. Mr. J, excuse me. The court, hang on. Mr. J, the proper way to make these arguments is I admit. What he's doing now is saying I believe. He's going to interject his personal beliefs into the evidence that is impermissible. The court, what is it that you're going to say, Mr. Owens? Mr. Owens says, I forgot now. Good job. Court, let's be careful with the interjecting own personal beliefs. Similarly, we can't use the golden rule. We can't ask the jurors to put themselves in the position of the party. Be careful with interjecting your personal beliefs. Okay, and they're back to open court. Adam Morona knew George Torres from Philly, okay? They were friends. They would talk to each other at the complex. Moreno went to Hill Ace's Hardware or Ace Hardware or whatever it was called. Well, the state attorney notifies Judge, I'm going to object to reading things that are not in evidence. Approach. Mr. J, Judge, this is completely improper. All he has to do is say the man made two different statements at two different times. It's completely... I don't believe that the statement that Mr. Moreno gave came into evidence. I know there was questions about the statement, Mr. J, but Judge, we concede he made an inconsistent statement. What's inappropriate is talking about our obligation to turn that statement over to them and going through all this. Just make the argument that he's an uncredible witness because he didn't make consistent statements. It does not have to come back to the state attorney has this. He's reading from his phone. It's not in evidence. Mr. Owens, I didn't read from my phone. I was reviewing the notes, but Judge, what happened was they're getting ready for trial and they call Mr. Moreno in. There's some discussion about an accident. Then all of a sudden he remembers additional evidence 4.5 years later, additional statements that my client made 4.5 years later. Court, okay. Mr. Owens, so they notified us. Mr. J, he's attacking the state. The court, I'm not going to let you read from a statement that's not in evidence. That's the primary objection. Mr. Owens, he's stating Tony Henderson brought it out, but he stated that in September. He changed his testimony. Now he's saying, Mr. J, if he can lower his voice, Mr. Owens, now he's saying Sarah Boone said I was teaching him a lesson. Court, I have that, yeah. And things got out of hand, And then I fell asleep. I had that in my notes, correct. And that's his new statement. Okay, then highlight those two things. I'm not going to let you read from the statement. Okay, because the statement is not in evidence. But I've got it on my phone. Jesus, James. So it's refreshing my memory. Court, that's fine. I just don't want you reading from. My concern was there was an issue with impeaching or potentially trying to impeach Detective Kopsel with an interview statement at some point in time that never came into evidence. I just want to be mindful that I'm not going to be relying on the things and arguing things that are not in evidence. In closing, that's my only point. I'm going to ask you to politely stop putting onus on the state. The state has influence on this, or the state did this. If you want to attack the evidence, that's fine, but we're getting dangerously close again to the ad hominem attack thing that we spoke about previously. Mr. Owen, Judge, it wasn't until he met with the state attorney preparing for trial that all of a sudden he had a change in his testimony implicating Sarah Boone. Court, there was a phone call with the ASA on or about September 23rd, and that information was addressed at that point in time. Mr. J, there's a jury instruction that says it's permissible for the court. You can't read into that. I agree. You've read it to the jury already. If you want to make the argument that the testimony was different and that goes to his credibility, you're absolutely free to do so. But I'm not going to let you read stuff to the jury that's not in evidence. I'm just asking you to politely, mindful of the ad hominem attacks with regards to the state. That's it. Judge, I don't know how they've chose to put on this case. They have a right, a fundamental right to attack their evidence and what, but you're not. You're not attacking the evidence. You're attacking the person. Mr. J, you're attacking the state's choice to do this. The court. The state's evidence shows this. The state's witness says that. The state testified to this. That was impeached or contradicted later. That's all acceptable. But the state did this. The state did this. The state did this. It's a different argument. It just is. It's a different argument. Mr. Owens. Judge, number one, the state got up there and claimed that George Torres has battered spouse. Court. They posed a question to the jury as to whether or not you have to question whether George Torres. That's different. That's a statement than a statement. Mr. Owens. All right. I just believe that you can attack the way the state attorney is presenting their case and the evidence that they're presenting. Court, attack the evidence. Do not attack the state attorney. That's the end of it. Thank you. Almost done. We have another one here. Mr. Owens says, okay, the prosecutor in the opening statement, when he was talking about George Torres passing away, started talking about Sarah Boone, and his quote was, well, I wrote it down, George, in Sarah Boone's mind, George Torres deserved it. George Torres deserved it. That's the position they're taking. He deserved to die. She loved the man. She wasn't trying to kill him. He also commented that, Judge, may we approach? Yes. Yes, sir, Mr. J. It's fair to point out that things that didn't come into evidence, but the evidence in this case was she said he deserved to be put in that position, to have to listen to her, and to feel her pain of being choked and cheated on. That's what Mr. Owens, Mr. J, excuse me, sir. Court, hang on, Mr. J. That's what we stated in opening statements in regards to putting him in a suitcase. We have never taken the position that she intended to kill him. The argument has been made repeatedly during the defense for whatever reason that she didn't intend to kill him, but that is a jury instruction. We don't have to prove that. It's improper. He's attacking me now. The argument is ad hominem, the court. What are these three other things that you wanted to address that were an opening other than what's already been addressed? Mr. Owens, he was implying George Torres died, and he pointed to my client in opening and said, she thinks he deserved it, or words to that effect, he deserved it. Court, I think the evidence it could be taken in such a way, based on the videos and other statements that were made, that the jury may be able to make that decision. Mr. Owens, the other comment made about all the batteries, the violence that George Torres committed on Sarah Boone, is he refers to a bunch of violent nonsense. That's his quote. I recall it. Mr. J, this isn't Mr. Owens. I'm entitled to comment in closing on statements the prosecutor made in opening. Response, Mr. J. It's one thing to say that the evidence doesn't support that. It's another thing just to attack the prosecutor, the court. So again, I'm going to allow you to address the issue. Just frame it with this is what was said in opening. This is what it's not accurate. Here, look at the pictures again, whatever you want to do, but let's just avoid the attack individually. Just say this is what was said in opening. Yes. Mr. J, approximately how much is longer? We're just circling back and forth to what Dr. Harper said 3 or 4 times, and it's the court. We've been at this don't worry about it. We've been at this for about an hour and a half ballparking, Mr. Owens. I mean, it's not like him. I'm kind of scatterbrained. So I'm going to bounce around a little bit, but I mean, I'm trying to save her life, Judge. Court, I know, I understand. I'm not putting a cap on you. Just ballpark from where we're at. Mr. Owens, I'll try. I feel like I'm finished. I'm getting close. I don't want to miss anything. The court, I understand. I'm afraid I'm going to miss something that one juror may think is important. Court, I understand. Are you going to have, since we're up here, are you going to have someone else jump into the breach, or are you going to conclude yourself? Mr. Owens, Tony Anderson said, James, why don't you do the deal? Then if I feel like I need to add something, I don't think he's planning on it unless he thinks I missed something. Okay, so the case law seems to be that it should be based on old common law. I'm looking at the case law back to the 1930s. There should be one lawyer in closing. That it was based on a statute in common law and Wharton treaties, I think, on criminal procedure. So I'll defer to you if you want to switch over. It's a matter of discretion. And just for the record, I'm referring to the Tyndale decision. It's Tyndale v. State, Florida Supreme Court, May 17th, 1930, 128 SO 494, and that decision is only a matter of discretion, but only one lawyer can? Court, but it should be. It can also cite Landrum v. State, Florida Supreme Court, March 1st, 1920, 84 SO 535, which says there are 2 or more counsel. The order in which they are to speak is determined by the court, citing the Wharton's treaties on criminal procedure. If you want to, I think it's odd, but I'll leave it to your discretion if you want to do it. Mr. Owens, we're planning on doing it. It's just that we found out they were using 2 lawyers to make the argument. That's when I said, Tony, they're using 2. I wasn't planning on it. With that, I'll let you point out I do remember the nonsense comment or words to that effect. I'll let you point that out, but let's just avoid particulars. Just as said in court, here's why it doesn't work. You may proceed, sir, and they return to open court. Getting near the end. When it described this violent, nonsensical relationship, that's exactly what it was. It's not downplaying the violence. She got stabbed. She had minor surgery. Got infected. Those injuries are real, but it doesn't apply to this case. They just don't apply when they use that self-defense instruction when she's the aggressor, if it's to be believed. Mr. Owens, Judge, I object. Approach. Basis of the objection. They don't apply in this case. We had 2 witnesses that testified she's the battered spouse, his own expert. But he's arguing the law that was just placed up there, and specifically, it was before that. He was talking about the injuries. The court. No. The statement right now was that the self-defense not being applicable due to his argument of her being the initial aggressor, and that's what the jury instruction. He was saying that the injuries did not apply to this case. That is not what he said. That's what I heard, Judge. He was talking about the interview. He talked about the violence, the prior violence, and it doesn't apply to the self-defense instruction. It doesn't apply to this case, is what he said. That's correct, under the law. Mr. Owens, to this case, battered spouse applies to this case. For him to say that, his own expert said she suffered from battered spouse. The court. I'm going to defer to the jury instruction that Mr. J is just making references to what he outlined as it identified. If you're the aggressor, this is the analysis you have to go through. Unless I've misstated the law, that's what identified in the jury instruction. So I don't find it, I'm taking your argument as improper argument or improper statement of the law, and that's not what I heard. That's not what I saw. Mr. J, Mr. Owens, I mean, he's gone through talking about the violence that he claimed was nonsense, just going through talking about the stab, it was a minor surgery, and it got infected, right, and all those things. But all that is not part of this case. The court, that's not what he said. He didn't say it was part of this case. That's not what he said. Oh, Mr. Owens, can we have it back? He just said it was part of the case. Judge, yes. Could you make a ruling? The objection is overruled. Thank you. Thank you. Judge, can I ask about time because he was trying to restrict my time? Oh my God, you whiny little bastard. He said I had been rambling for an hour and a half or however long it was. He didn't complain about how long it was. He did say you were kind of rambling. He did insinuate, but he didn't complain about how long it was. Approximately 16 minutes. All right, where's their total time? I think Mr. Cacciatore is about an hour and 20. I'm wrapping it up, a little shy of 2 hours. Objection overruled, and they're back to open court. Final at the bench in this document. In closing, let me remind you it's important that you follow the laws spelled out in these instructions to assign your verdict. There are no other laws that apply to this case. Even if you do not like the laws that must be applied, you must use them. For more than 2 centuries, you have lived by the Constitution, the law. No juror has the right to violate the laws we all share. Can the parties approach? Any objections to the instructions? No additions or corrections. Thank you. Other than those previously mentioned in the conference, and we're done. We're done. That is all of the what I would view as relevant bench talks. Not the best video. Not done the best, way too much coughing, done way too late, done way too tired, and I apologize for it. Maybe I'll have to do a revisit of these 2,529 pages at some point, right? It's pretty long. But I wanted to get it out because it's out there, and I like to cover it when it's out there. It is now like 7 a.m. It's going to be later than that by the time I get this uploaded. I'll probably just schedule this for like somewhere, I don't know, some point. And I probably won't do a premiere because I won't be awake because I'm going to be asleep. Yeah. It was interesting because you got to hear how angry James Owens got. Let's go find that really angry part before I quit. What did he say? There's something really angry in here. I think it was after the arm thing. But he got so mad at certain points. Oh, there it is. Judge, he objects to everything. He objects to everything. He thinks he knows it all, objects to everything. This is my chance. And this, stop. That right there. That's an ad hominem attack. Oh, wow. But, I mean, the thing is, we can't expect James Owens to know that's an ad hominem attack. He just learned that the day before Tuesday is Monday.